in two, but I knew that today it will come, but somehow my name is not printed in the list. I am otherwise not well. Let it come anytime after 2 weeks.
Is it after notice matter?
Yes, after notice matter.
Who is appearing?
After 56, I am for the informant.
Now, who is the other side? Is there any stay operating?
Yes, yes.
So the other side should.
Cognizance is crossing, there must be stay.
It's all right. But who is the?
I am opposite party. Stay is against me.
Stay is against you.
Yes.
That case, my lord, specific here, urgent today, my lord.
Yes, I know that.
Some
Here is the
council,
problem. Stay is
some
operating.
council appearing for the petitioner from Delhi, my lord.
Okay. Put a mark. I will adjourn.
Any day after 2 weeks, ma'am.
Okay. I'll adjourn it. Put a mark and when the matter is called up and just tell.
Okay.
My lord, I beg
I
your
beg the
lordship pardon, my lord. Item number 49. I have some personal difficulty.
49 adjourn.
But-
After notice,
Yes.
you got stay.
No stay. No stay.
I may pardon, my lord. Item number 63. I pray for an adjournment, my lord.
Why?
My lord, there is a death in the family of the petitioner.
Okay.
Fresh admission, my lord. Not item 15, my lord.
One-
That matter will also kindly encapsulate that to dispose of both the affairs, that electricity matter, that consuming of high.
But he has some bereavement in the family.
Yesterday he intimated to.
Let it be.
Fresh admission mentioned Monday.
You also keep it to next week.
We'll see. Give a date, because there is a bereavement.
Item 38 to 39, my lord, fresh admission.
1 minute, one after. Yes.
My lord, item 50.
Huh?
2 weeks time may be granted.
Okay.
2 weeks, after 2 weeks we'll.
My lord, item 38 and 39, I prepare next week, my lord.
Why?
Fresh admission matter.
The lordship may had in part.
Not ready, my lord.
Lordship had in
What
part.
to do? No, there is no point because part has no meaning.
My item 15, my lord.
38 and 39, not ready today, my lord.
38, 39, not ready today. You have a lot of time, you get ready.
My lord, not ready. Yesterday was puja, my lord, not ready today.
Now you have a lot of time. I'll take it at 2 o'clock if you
Next week, in any day, my lord.
want. Okay,
38, 39,
38. Rest matters.
fresh matter. Bless.
Item 15, my lord. One week after, my lord. I am searching some decision. Pokso Act, question compromising. 1 week after us.
I have kept some judgment
That case, my
reserved.
lord, I have been filing the canon.
No, you take it.
1 week after, my lord.
I'm going to write a judgment. You may get benefit, you may not get benefit.
My lord, that reason, my lord, 1 week after us.
Okay.
15, my lord.
You take that.
15. 1 5.
Jyoti, you take written submission there in Poksumet.
Pardon, my lord, item 24. Item 24, my lord.
24.
Yes, my lord.
Yes.
The conducting council is ill, so I.
After fresh matter or?
Press matter.
Evidence?
I don't, Honorable Achyutan Patnaik, I don't,
You has decided to not to do the case in the court. Or
I don't, I don't, kindly industry,
we'll adjourn it. Fresh matter,
press matter.
but we don't know when it will come. Yes.
Vigilance matter, vigilance council not there.
Let it be.
Vigilance matter.
Yes. Any mentioning? No. Oh, how many matters are there today? Huh? When we reach less number of matters, lot of adjournments. Problem. Anyway, yes. Hmm? So we will be free of what? Okay, one.
But I may be permitted not with your lordship's kind permission.
Yes, 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 yes.
But CRLMC 5528 of
Mentioning.
I guess.
What do you
Since
want?
I have been mentioning since
What is the urgency?
urgency is the main accused has been acquitted. Old mother and father, they have settlement is there for quashing of
Okay, okay. Settlement, lease. That is the
5528 5523 of 23. 5528, sorry.
2828.
Wait, 28.
5528 of 23.
23.
Okay, we will list it. No problem. Next week.
Okay.
Okay. Yes. Password.
Yeah, please, ma'am.
So Belgium matter, lordship.
Belgium.
Yes.
When you got bail?
Yes, my lord.
When?
13 to 2000, page 12, lordship.
page 12, Lordship,
Yes, 13 to
2023. And the warrant issued, Lordship, the same date, case was
500. Okay. Next.
May please last my lord, Belgium matter, my lord. Already has one bail my lord, 11/10/2021. The NBW issues 22/11/2023, my lord.
Okay. 500.
Oh, bless me.
May I please, Belgium matter, madam.
Yes.
ଅର୍ଡର ଡେଟ୍ 4/4/2019 ବେଲ୍ ଥିଲେ 23/8/2013 ବେଲ୍ ଥିଲେ
2019.
ମାଇ ଲର୍ଡ
How many of you are there?
ମାନେ ଏଥିରେ 19 ହେଇଛି ବାହାରେ ଥିଲା ଆଉ ଜାଣିନି ଆଉଟ ଅଫ୍ ଓଡ଼ିଶା କେରଳରେ ଥିଲା
1000.
ବେଶୀ ହେଇଯିବ ଆଜ୍ଞା 500 ଟଙ୍କା
500.
ବେଲଜିୟମ ମେଟର 18/23 ଆଜ୍ଞା ଇସ୍ୟୁ ହେଇଛି ଏନବିଡବ୍ଲ୍ୟୁ।
ଆଚ୍ଛା।
ବେଲଟା ଥିଲା
Bail.
ବେଲଟା ସେଇଟା ମତେ ଇନଫର୍ମ କରିନାହାନ୍ତି ତଳକୋଟ।
Was in bail.
ୟେସ୍ ମ୍ୟାଡ଼ାମ।
He was on bail. Then. 500. Yes.
Obliged.
I please, your Lordship, Belgium matter.
Yes.
Uh,
You are on bail?
Yes, 41 notice was issued against.
The petitioner, the confirmation submission that the petitioner has received the notice under section 41C of CRPC. However, due to his default in appearance in the court, the court below JMFCH has issued warrant NBW against him by the order dated 18/8/2023. 500.
My pleasure, Lordship.
Okay.
My pleasure, Lordship.
Yes.
My lord, Belgium matter.
8, huh?
7 item.
You were on bail?
My lord.
When date?
My lord, in 2018, particular date was not informed by the lower court
No, he
advocate.
was on bail for the
My lord.
NBW on
4/4/2023.
500.
Oh, bless.
May I please, Belgium matter, my lord.
Yes.
ଏନବିଡବ୍ଲ୍ୟୁ ଅର୍ଡର ଡେଟ୍ରେ 19/10/2023
Wait,
I-
wait.
ଆଇ ମିନ୍ ବେଲ୍ 17/3/22 ବେଲ୍ ଥିଲା
17/22, 19/10. ठीक है 500.
ଓ ବ୍ଲେସ୍ ମ୍ୟାମ୍
My lord, Belgium matter, my lord.
Yes.
I am on bail on 18/4/2012.
Hmm.
NBW issue on 11/5/15.
15.
My lord.
How many of you? Now you have bail.
My lord, disabled person. My lord, kindly see the annexed 2. Physical handicap. My lord, can see. Annexed 2.
2.
ଆଜ୍ଞା।
Physical handicap ହେଲେ କଣ ହେଲା? 2015 ରୁ ଯିବେନି ଆଉ କଣ କରିବେ? ଚलो 500 handicap. ठीक 500. Yes.
My lord, my senior is not present, so kindly pass over the matter.
But
Obliged, my lord.
if your senior doesn't come, then you have to argue. After. Okay.
Oh,
Get ready. Where is your file?
actually, I have no file, so.
Get the file, get ready. I will not adjourn it once you pass.
Obliged, my
Get
lord.
ready, come with the file, okay?
Obliged, my lord.
ବେଲଜିୟମ ମ୍ୟାଟର
Yes.
31/8/2016 ବେଲ୍ 6/7/2023 NBW
500.
12 well, I prefer adjournment, man.
Why?
I'm not ready today.
Get ready, I will pass it over after lunch.
Aji, I would know. Any time.
Not mentally ready or physically ready?
Mentally.
Okay, adjourn. Okay. 13. When generally we less number of matter, all the matters are adjourned. If you leave more matter, then all matters are heard.
Item 13 and 14, your lordship, I pray for an adjournment, my lordship.
See, adjournment. 14. Adjourn.
No, 15 lordships, 10 lordships.
10 is already over. 10 somebody asked.
My lord, she will do, my lord. The lordship can
Wait, she will do at 2 o'clock.
Yes,
She will do at 2 o'clock.
2 o'clock.
Give the file.
Yes, sir.
Get ready, read the file and come at 2 o'clock. And if you come, then the cost will be very heavy, I tell you. Yes.
60.
Yes.
16,
Pass over.
17,
Pass over.
18.
My lord, taken up next week anytime, my lord. Appearance of the both the parties, my lord. Matter has already amicable settled.
Next week.
Next week,
Okay.
23rd.
You bring them so that we.
Yes,
Okay.
23rd.
19.
May I please? The petitioner is challenging the order of charge, my lord, on the sole ground that the London trial court,
Charge has been framed.
my lord.
Then revision. Against the framing of charge, you will file a revision.
The framing of charge, my lord, kindly see,
But just
without considering my discharge petition, my lord.
you may be correct, but revision like.
There are
And
charge
according the petitioner seeks permission to withdraw this petition for filing appropriate proceeding and proceeding. This is a matter arising out of an order by which the charges have been framed against the petition. The petition is dismissed as withdrawn with a liberty as finally revision.
Okay.
20.
Pass over.
21.
Pass over.
22.
Pass over.
23.
My lord, 23 also charge.
Same.
Charge.
Same out of 23. That he will file a revision. Dispose. Okay. Next.
25.
24. Mention 25.
25.
Pass over.
26.
Yes. Pass over.
27.
Pass over.
28.
Pass over. 29.
29.
30.
30.
ये पास ओवर क्या है? 31.
31.
Your in the board things are displayed. 31.
31.
32.
32.
Display कर दिया.
Display 33.
33. 34.
Speedy helper says slow ଆସିବେ. Cute करे.
Where is that? 30. 34 ना 32 देखो थी 34 करो नहीं 32 still yes 34 okay. Yes, 35.
35.
36.
36. 37.
Yes.
My please, Your Honor. Right, the petitioner in this case is seeking for quashing of the FIR and the criminal proceeding, my lord.
FIR.
FIR.
Hmm.
Here in this case,
Who are you?
I'm the main accused, my
Husband.
husband.
No, this matrimonial is good.
No, my lord, when the offense took place, at that point of time, we were not married. Subsequently, we got married. And I have a child with the OP number 2.
We know what to.
Ma'am.
That is, no.
OP number 3. OP number 2 is the father of the victim.
Himalaya. What is the allegation against you?
Allegation is that in 26/8/2016, the daughter of the opposite part number 2, she said that she had pain in her stomach. When he took her to the hospital, the doctor diagnosed that she was 7 months pregnant. And when they contacted the petitioner denied to marry the victim. That is the allegation, man. So the affair was lost.
Under 376. Yes.
Obliged.
Since
Which
matter, all the matters are done, your lordship today also delegate to your procedure, my lord.
Which item you are?
Item 30.
30. Then in the reverse cycle we will go because of the exceptional circumstances. Okay. 30. Okay. 30. Yes.
Cancer patient 205. Last date at time.
Good. Cancer patient said I already disposed of. Your lordship, can you recall the Supreme Court, the 2 lawyers came on that day. Exactly, I submitted before your lordship that 4 cases has been filed in different ways. And he has not given any reference. That is why your lordship disposed of that application, giving liberty to the petitioner to raise this point. And available under law before the trial court, and accordingly the application has been disposed of with a long order. And the same prayer made by my senior. Yes,
situation.
same prayer.
Same
That is.
yes.
That application number is
Same
127.
Same.
Yes, my lord. That application is 127, and this application perhaps 27. 2 more. I don't have file. That is why I am in confused.
How can we have a
Different
order?
27.
27.
How many cases you have?
Yes, exactly.
No, one case.
No. Confirm. Also one though. Yes. 127 is one application.
କୋର୍ଟଟା କହୁଛନ୍ତି ବୁଝୁ କାଇଁ ବ୍ୟସ୍ତ କାଇଁ ହଉଛୁ ଆର କିଛି ଅଲଗା କେସ୍ ଅଛି କି
ପଡିଛି ପେଣ୍ଡିଂ ଅଛି ହାଇକୋର୍ଟ ପେଣ୍ଡିଂ ଅଛି ଆଉ ସେମ୍ ଆପଣଙ୍କ ପ୍ରେୟାର ରେ ସେ ଅର୍ଡର ନେଇ ସାଇଲେ
ରେ ଏନି କ୍ରିମିନାଲ ଆଣ୍ଟିଜେଣ୍ଟ ଇଜ ଦେयर
ନା ଆଣ୍ଟିଜେଣ୍ଟ କଥା କହୁନି
କୋର୍ଟ ଇଜ ଆସ୍କିଂ ଫର दैट
Many.
No,
One case we dealt. In that case also, lot of concealments. The lawyer was not known, so the taking into consideration, we passed the order.
No, I'm clarifying. One anticipated bail application was filed. Interim protection was granted. Finally, it was dismissed. Subsequently, 482 application was filed.
Yes.
This honorable court dismissed the 482 application.
Right.
Here, this is a case. My 205.
Revision application was filed. That was pending also. So far my memory is concerned. I have given all the information before lordship on that day.
I think that is the. I have mentioned that in the.
Exactly. I have your lordship has already mentioned.
Where is that order? Do you have?
Within 5 minutes, I will
produce bail application.
No. The other matter pertaining to the same.
Pending. I don't think any application is pending.
Yes. Revision application is pending. Just now I will provide all these things. My clerk is.
I am just passing it over.
Yes.
For challenging cognizance.
205. Same
withdraw.
Same application.
I will withdraw.
That's
Yes. I fairly admit if any application is pending, revision application.
Not only withdraw, sir. I will lease that matter also to recall that order.
Correct. Absolutely correct.
And that has already been.
At least dignity of the court. Yes.
Lawyer doesn't know. That lawyer didn't know.
Exactly.
Yes, dignity of the court should not be.
Let us see that order.
Yes,
I have opened.
If any application pending for challenging 205,
my lord, 1A BLPL number 13 is subject to correction of my learned senior. 1386 of 2023, that was disposed of 31/3/2023 and dismissed. That was dismissed. And one application is CRLMC 172 of 2024, which your lordship was dismissed with their prayer that we are sorry, we could not able to know, the client has not provided any information. That is why your lordship considered sympathetically and 205 has been
because of the cancer patient and all.
Yes, exactly, my lord. Then one revision application is pending.
And with a 5,000 rupees cost.
Yes, my lord. Yes, lordship. Right, oblige, my lord. Your lordship has
Where is that order? Show him.
My lord,
Oh, 1 minute, I'm passing it over. In any case, it was passed over, just check it out.
one revision application is pending, that is 673 of 2023. 673.
Check it up.
I'll check it.
And everything is written in that order. Just give that order to him.
Yes, I am giving.
I'll check it.
Pass over.
2023. Again.
Pass over. Huh?
170.
No, 2 o'clock I'll do it. Huh?
Tomorrow.
Order, in the order, everything is written. You
Yes,
get
everything.
five pages order.
I am not in that. He's making a mention that another revision application.
One
the self-same
Everything is written in that order.
172
That
by
482 application,
2023.
I know that.
Not 482.
2024, sorry, 2024.
I verified.
205 exemption only.
24.
That was also against the rejection of 205.
Yes, 205 application, I surrendered my lord's pursuant to your lordship direction.
You just read why.
Yes, that's why I said.
There is no point. Read it.
How many clients, how many advocates he has contacted, I don't know.
I don't know.
Surprisingly.
Unacceptable.
I'll
This
check
is
it.
unacceptable. Yes.
Move copy and yes.
Item 22.
I pass it over. I'll take it up. Let me call it. You will not there. I'll just pass. Yes. Next. 38. Yes, 38. 39.
Bhargav, file ta Bhargav, 130.
40, my lord, I pray next week.
What, 38?
40.
Why?
My lord, in the meantime, there is a compromise between the parties. Initially 363, 34. Subsequently 363, 366, 379 has been charge sheet submitted against the petitioner. The matter was.
Okay, next. Adjourn it. देख के दे दिया.
Lordship 38 item.
40.
40 is adjourned, 38 pass over. 41. Pass over. 42.
Kindly pass over.
Pass over.
43.
Pass over.
Pass over.
44.
My lord, kindly pass over.
Pass over.
45. 45.
ଆପଣ କର।
Pass over. 46. 46. Pass over. 47. Pass over. 48. 48. Pass over. 50. 50. Yes.
May I please, Your Lordship?
Yes.
This is that release of Gutka case, my lord. Your Lordship has already heard it at length on the last occasion. And Your Lordship wanted me to file an affidavit under section 65B, my lord. I am filing the affidavit, my lord.
ବୁଝିଲି ମନେ ପଡିଗଲା
Those, my lord, tax invoices.
I think I have passed some order on
yes
11th of January.
11/1/2024 your lordship already passed the order.
Yes. That day Your Lordship had it, and
ଜାଣିଲି
Yes, Mr. Maharaj.
My lord.
There are 2 points at para 4. I have,
Yes, your lordship has given direction to get instruction. And I have taken instruction with reference to the, I am reading, my lord. With reference to the letter and subject stated above, I have the honor to submit that as per your direction, I have verified the case record and found the IO has not complied the section under section 13(2) of the Copyright Act.
Okay.
He has not complied. That has been instruction given.
Yes.
During course of investigation, I made request to the Assistant Commissioner of City and GST Assessment Unity, Gunpur, regarding genuineness of the invoices. You'll also directed that invoices, page 15 to 32. Annexed from page number 15 to page number 31, I had received opinion from him that the tax invoices bearing number 1608, 1609, 1610, 1613 and 1619 dated 14/6/2022, 5 numbers are found genuine. The genuineness of the rest of the tax invoices, the rest, because many invoices are there. My learned senior has given me. That is 1611.
How many of them?
My lord, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. 11 are not
genuine.
Genuine or no information I have received.
5 of them.
No
are
information.
No information I
No
have received.
information, that doesn't mean that it is not.
No information, because
Well,
the
these are only
commissioner has not given any, nothing has been found in their subject, Milord. So these are the information given. Your lordship, one information, your lordship may kindly take a note of that.
What do you say, Mr. Mishra?
My lord, what they say, my lord, that it is no information has been received with regard to the other, my lord. My lord, that doesn't by itself mean.
Available.
No, it is very much all the documents. I am also filing the affidavits that all the documents I have obtained electronically from the computer, my lord, which are the two copies.
Give the affidavit to
Yes,
him
my lord.
and give a copy of instruction to him.
Yes, sir.
And
What a copy tango dena
next week.
Yes.
In that light of the instruction, just address
Yes.
and give that affidavit.
Gote copy tango dena.
Mu dei dichi.
No, mu gote copy dou.
Mr. Mishra.
Gote copy de de.
ଟିକେ ସେଟା ଦେ।
Filed an
affidavit ଟିକେ ଦିଅ ସେଟା। affidavit ଟା ମୁଁ ଗୋଟେ correction ଟା ଭୁଲ କରି।
Section 65B of evidence.
Original টা
12/2/2020.
ମତେ ଟିକେ affidavit ଟା ମୁଁ ତ
Maharaja
ମତେ carry out କରିବା ପାଇଁ ଭୁଲି।
please on record the written instruction which is taken on record for further consideration. Is the matter on the
My lord.
Yes. Next week. Yes.
31 টা ଅଛି, can your lordship take up that matter, because after recess I have a fixed matter and
51.
31
Huh?
31 টা pass over here. If your lordship can take it up.
31 you do it and come, I will wait for you. Otherwise I recommend it because I can't go in reverse.
ଦିଟା ବେଳକୁ specifically fix ହେଇଛି
Okay,
court
let
number
it be 3
11.
o'clock. How does it make?
ଭାଇନା ସେଟା ଦିଅ ତ affidavit।
Yes. 51.
51
pass. 52 also. So after recess till 5 o'clock we have to
51,
all the matters. Yes.
53.
Yes.
खाली के लिखा हुआ affidavit filed by the defense counsel
53.
and instruction given to the defense counsel.
Oh, nobody
Matter put
coming.
Matter happened. 53 pass over. 55. Yes. 56 happened. 56 happened.
Pass over.
56 my lord, Mr. Mishra, HS Mishra my lord, the first order.
Passing for pass over.
खाली लिखूंगा affidavit filed by defense.
57. Yes. What do you want?
57.
Who is appearing for petitioner? Behra is appearing. Let me pass over. No. Do you have an interim order?
Yes, one that is there.
Operating against you? Oh, then it's urgent. Okay. Interim order to continue. Yes. 58.
Item 58, there are three matters.
Yes.
Last two matter I am appearing. The first matter, learned senior counsel is appearing. And the informant also is appearing that case, but he is not there. Here, this is a case, my lord. FIR was lodged under section 302. Charge sheet was submitted. 338 and 228, very lower offenses. What informant did, cognizance taken, I appeared, 205 application was filed. Informant filed a protest petition. Learned magistrate took inquiry under section 202 and cognizance was taken under section 302.
Right.
Now I have challenged that quashing the entire proceeding on the ground. While protest petition was filed for reinvestigation by SIT, not for Muller's protest petition to be treated as a complaint petition take cognizance. It was not there. This is number one. Prayer is for further investigation. Number two, since charge sheet has already been submitted, whether informant has a right to file a protest petition on the basis of protest petition to turn as a complaint case. My lord knows TT Anthony till today.
No,
There
but
cannot be two.
If there is one of if the initial FIR is against for certain offences and the
Yes.
offences are taken out
Yes.
in the charge sheet, he can
Yes.
file a protest petition to that
He
extent.
can file a separate complaint petition, complaint case under section 200. My lord,
Right.
whether protest petition will be filed after final report under section 179, 169. If the final report was submitted, then only 169 the protest petition.
Final report qua the offences which is not taken into consideration.
No, if final report is submitted, three options lies with the magistrate. But he ignored the final report, he can take
You are
cognizance.
questioning the maintainability of the probate petition itself.
Yes.
So, show me any judgment if
Yes, my lord, I have, nobody is there.
Let's say, item 58, bring for and pass over, let's say. The contending counsel is on his legs.
Mr. Raghuda, are you ready with this? Item 59. Pass over means? Pass over. Yes. 59.
My pleasure. My lord, this matter relates to questioning of affair. And the last occasion that informant's advocate has taken time because compromise is going on, and that informant is suffering from rheumatism, and we are praying for another
2 weeks.
4 weeks, my lord.
Urgent.
Obliged.
Yes. Pass over.
62.
What is the pass over?
64.
Item number 64 on behalf of Satyapratam, they kindly next week take this matter.
Done, my lord, item 62, my lord.
Huh?
Item 62.
Passed over. Yes.
65, Lordship, item 65. I'm appearing for the opposite party number 2, my lord. Just now I received the Vakalatnama, my lord. So need some time. Therefore, I'm asking.
65, huh?
65.
Alright.
Just now appearing for the opposite
For
party.
enter appearance for opposite party number
2.
2 and file local nama. Courage, your website. Taken out of court. Matter is urgent to. Yes.
66.
No, 66 not. Where cognizance was challenged on the cognizance under section 307 was filed, but not. A divorce suit is pending in between the son of the petitioner and the complainant in this case,
Yes.
Lord, now it seems your lordship was pleased to issue notice.
Service is effective there.
Service has been affected, and I find from the cause list that some Ajit Kumar Mahanti has appeared now.
Yes.
They have already filed a settlement petition before the family court, my lord, wherein it has been stipulated that she will, my lord, that the petitioner will cooperate and take all necessary steps for withdrawal, disposal of the criminal cases initiated by her against the respondent and his family
That is
members.
13B application.
Yes, my lord.
13B application.
So the joint petition is required to be filed before your lordship.
Now, if they appear through VC also, joint petition is not required. I can pass it here. Let them appear at 2 o'clock. I'll do it.
Council not coming. Council is not coming. The first date after their appearance.
Let us pass it over. Let us see if somebody comes. Then I'll ask them to appear through VC so that we can do it.
No, he must be instructed to make her present in the VC.
I'll just note it down. I'll just tell you. The moment he comes
and the interim order may be continued.
Interim order will continue. Interim order.
Obliged, madam. Your lordship wants to, will I hand over that copy of that settlement filed before the
family court?
That has come on record already.
No, that is not there. I don't think so. It is after your lordship issued notice all this development took place.
Okay. Let him come then. Let him come. We will settle it out. Simply pass it over. Note down. Somebody should be there from you.
He is there.
Okay.
Yes.
Yes. Tell me. You have settled the dispute.
My lord, as per the instruction, matter has been settled.
Can they appear through VC today? We will close it.
I had instruction, she will have to come, but till
She need not come through VC. Let her appear at 2 o'clock. I'll pass it.
may call it tomorrow.
Tomorrow.
I'll inform she will come.
Put it tomorrow.
Contact
Let them appear in the VC. We'll
either she will appear on VC or she will come down.
Whatever it is.
Whatever. We'll call. Okay.
The interim order may be continued.
Interim order to continue till tomorrow, of course.
And they have already settled. She has already received the money as per my
So
instruction.
that's the reason we will.
That's she has to come and say.
She has आपण काही
Board adjusted.
Your lordship is fixing it at
Tomorrow.
tomorrow at
2 o'clock.
2 o'clock.
Fix it 2 o'clock. I'll just take it up.
May I please your lordship?
Yes, yes, tell me.
Uh,
Okay.
My lord, I am appearing on behalf of Mr. C.R. Sahu.
Yes.
Uh, My lord, this is an Belgium matter. Due to non-providing of steps, an NBW is issued.
When you have got the bail?
My lord?
When you got the bail?
My lord, the first bail was issued on 3/04/2018.
How many of you are there? One or two?
Two, my lord.
Petitioner number one got the bail on? When you got the bail? First petitioner number one.
It's on 3/4/2018.
What about petitioner number two?
The same date. Both are the same date.
NBW issued on?
On 25/04/2022.
500. Cost is 500.
Yeah.
Cost. Cost. Yes.
Obliged, my lord.
You. I have already said on 7.
May I please?
11? 60. Okay.
Cognizance taken under section 406 and 409 of 34 IPC. My lord. Here the present petition is the peon of the society. And having no financial accountability with the society, my lord. Neither he was collected the
This
money.
is against the cognizance order.
Cognizance.
Discharge.
Charge has been framed.
Yes, my lord.
Charge framed.
Yes.
You are not challenging charge.
Yes, I have filed the discharge petition, my lord.
Thereafter, charge has been framed or not?
No, thereafter does not.
If charge is framed, then revision has to be filed.
20.
No, charge has not been filed.
31 to 20.
Who-
Recently has a sold punch and is ordered 16.5
No,
to
charge
both.
has not-
You have a challenge ordered 16.5 to 23.
I have challenged the order. No.
Prayer, your prayer.
So I have filed a petition under section 227. Before
It
decision.
was rejected and you file a
There are
revision.
revision filed.
Revision also rejected. Now you
Rejected.
are.
Thereafter I have filed this.
Yes, tell me. What is your case?
I am the peon of the society, my lord.
Yes.
Absolutely, there is no allegation with regard to the transaction because I am not the finance secretary of the society, nor I have made any transaction with regard.
Let us see what is the allegation.
Your lordship.
Why the revision court has rejected your application? Here is the matter.
If-
Come to page 23, para 7. Page 23, para 7.
Yes, my lord.
Yes.
Paired with the materials available on record, it is found that the learned trial court, after hearing the concerned parties and a perusal of the case record, has observed at the very outset it must be made clear that this court exercises the power of judicial magistrate first class so far as the present case is concerned. Hence, section 239 CRPC should have been cited by the learned defense counsel, not section 227 and 228 of the CRPC, as cited by him. Having said so, so far as discharge the accused in the spirit of section 239 CRPC, I have perused the available documents in the case record. I am of the considered view that a prima facie case exists to proceed against the accused by framing charge under appropriate section of IPC. To further consolidate my view, I am placing reliance upon a decision reported in Ashok Basdev and Patwardhan versus State of Orissa reported in 2018 OCR 96, where it has been held by the Honorable Court that charge can be framed even on the grave suspicion against the accused, and the probative value of the materials cannot be gone into at the time of framing of charge. In view of the decision of the Honorable Court, I am of the opinion that at this stage there is no necessity to delve deep into the case when a prima facie case has already been made out. After all, the law does not permit mini trial at this stage. Well, also kind of the statement of the president.
That's what the court says, that mini trial cannot be conducted.
Because
You
absolutely
want me to go to each and every evidence. Not evidence.
No,
what
because
your
your lordship,
statement.
rules 41 of the OCC actually clearly provides me that is absolutely peon having no financial transaction.
What is the main allegation against the accused persons?
Accused persons,
Let us see the allegation in the charge sheet.
Attabandhu Jena, who was the secretary of the society, and he has done everything, including the preparation of the documents, everything he has done. I am the only peon.
Where is
I
the
have
charge sheet? Let us.
I am giving the charge sheet copy.
Where is that? Where is that?
I have additional. I am filed by way of memo. Your last
Yes,
your lordship
yes.
wanted to.
Let us see.
Yes.
Let us read it. Read out.
Your lordship, the statement.
Come to
A statement of the president, my lord. Your lordship,
Come to
absolutely.
the column 16. What is the brief fact of the case? Charge sheet, column 16.
Yes, my lord. Yes, ma'am.
Yes.
This case is that on 11/7/2019.
What is your name?
My name is Minoketan Das.
Yes.
The case is that on 11/7/2019 at 9:30 p.m. the written report of the complainant at Chumarani Jenna, wife of Vijay Kumar Jenna of village Sadanandapur, Bhuasana PS Tihidi district Bhadrak, reported in writing before the OIC Tihidi as alleged therein that she is working as the president of the Guamala Seva Samvaya Samiti since 5/4/17. The general body meeting of the cooperative society was held on 1/2/2019, and in this meeting accused the assistant secretary Attabandhu Jenna, son of Keshav.
All the names are there in the Minakatan Das.
Minakatan in my lord.
So were discharged from their duty. And
Were discharged from the duty.
So that the accused Attabandhu Jenna and the other accused persons in the case were involved in the misappropriation of the accused Attabandhu Jenna and pure Minakatan are mastermind behind this misappropriation and responsible for this. As the offender committed by the accused intimated the fact that so and so. And during the course of investigation of this court, so whether the available statement has recorded statement and well. So the fact and the accused that's Attabandhu Jenna. Report on the same day and another the case from show you are stated to be the mastermind. Come on, the statement. Let us see statement of
You are this statement of the constituent statement of the president.
Page 25. Come.
Yes. ମୋ ନାମ ଚୁମାରାଣୀ ଜେନା। ମୁଁ ଆଜି ଆପଣଙ୍କ ନିକଟରେ ଏହି ବୟାନ ଦେଇଅଛୁ କି ଯେ ମୁଁ ଗୁଆମାଳ ସେବା ସମାଜ ସମିତି ପରିଚାଳନା ପରିଷଦ ଭାରପ୍ରାପ୍ତ ସଭାନେତ୍ରୀ ଭାବେ ଗତ ତା 5/4/2017 ତାରିଖରୁ କାର୍ଯ୍ୟ କରି ଆସୁଛି। ଅର୍ଥବନ୍ଧୁ ଜେନା ମଧ୍ୟ ଉକ୍ତ ସଂସ୍ଥାର ସଚିବ ଭାବରେ କାମ କରନ୍ତି। ଗତ 25/5/2019 ତାକୁ ସସ୍ପେଣ୍ଡ କରାଗଲା କାରଣ ସେ ଲୋକ ଆମ ସଂସ୍ଥାର ବହୁତ ନିରୀହ ଲୋକ ପଇସା ନେଇ କାମ କରନ୍ତି। ବହୁତ ନିରୀହ ଲୋକ ଆସି ପଇସା ନେଇ କାମ କରନ୍ତି, କିନ୍ତୁ ଯେଉଁ ନିରୀହ ଲୋକମାନେ ପଇସା ଜମା କରନ୍ତି ଅର୍ଥବନ୍ଧୁ ଜେନା ସେଇ ରେଜିଷ୍ଟରରେ ଚଢାନ୍ତି ନାହିଁ। ମୁଁ ପଛରେ କଣ ପାଇଁ ଜିନିଷ କରନ୍ତି ମୁଁ ପରେ ପଢା ବହି ହବ କହି ଏମିତି ଠକନ୍ତି। ଏହି କାମ ପାଇଁ ମୁଁ ପୂର୍ବରୁ ବହୁତ ଥର ସସ୍ପେଣ୍ଡ ହୋଇଛନ୍ତି। ଏହି କାମ ପାଇଁ ସେ ପୂର୍ବରୁ ବହୁତ କିଛି ଦିନ ତଳେ କୋଉଠି ବ୍ୟାଙ୍କ ତିହିଡି ଯେତେ ଇନକ୍ୱାରି କଲା ତାଙ୍କ ନାଁରେ ପାଖାପାଖି 13 ଲକ୍ଷ ଟଙ୍କା ହଡପ କରିଛି ବୋଲି ଜଣା ପଡିଲା। ପୁଣି ଭଦ୍ରକରେ ARCS ମ୍ୟାଡାମଙ୍କ ଦ୍ୱାରା ଯେବେ ଇନ୍ସପେକ୍ସନ ହେଲା ପରେ ଇନକ୍ୱାରି ଜଣା ପଡିଲା ଯେ ପ୍ରାୟ 5 ଲକ୍ଷ ଟଙ୍କା ସେ ହଡପ କରିଛି। ଆମ ସଂସ୍ଥାର ସବୁ ମେମ୍ବର କହିଲୁ ଯାହା ପଇସା ନେଇଛ ଦେଇଦିଅ, କିନ୍ତୁ ସେ ଆମମାନଙ୍କ କଥା ଶୁଣିଲେ ନାହିଁ କି ପଇସା ମଧ୍ୟ ଦେଲେ ନାହିଁ। ଆହୁରି ମଧ୍ୟ ଆମ୍ଭ ଅଫିସ କାଗଜପତ୍ର ସବୁ ଯଥା ଡେ ବୁକ୍ ଅଫିସ ପିରିୟଡ ସବୁ କେଉଁଆଡେ ନେଇଯାଇଛି। ଆମ୍ଭେ ପୋଲିସ ମଧ୍ୟ ପାଉନୁ। ସେ ଅଫିସ ରେକର୍ଡ ଅଫିସ ରେକର୍ଡ ପତ୍ର ନ ଦେବାରୁ ନିରୀହ ଲୋକମାନେ ତାଙ୍କ ଉପରେ ହିସାବ କିତାବ କିଛି ପଇସା ପାଉନାହାନ୍ତି ଓ ହଇରାଣ ଶିକାର ହେଉଛନ୍ତି। ମୁଁ ଏହାର କିଛି ଉପାୟ ନ ପାଇ absolutely that president has lost the affair against the present petitioner.
Yes.
He has not whispered a single word in the
anyway, Ajay Shetty, because the records are missing. You are the
I am the peon.
You are
your lordship financial transaction.
The mastermind.
Absolutely, there is no audit report against me.
That are the other things, my lord. And see FIR, my lord, the second paragraph. Priyono Minaketana Dasanଙ୍କ ବିରୁଦ୍ଧରେ ARCS ଭଦ୍ରକଙ୍କ ଲେଟର ନମ୍ବର 77 ଅନୁସାରେ 3,678 ଟଙ୍କା ନିଜ ନାମରେ ଓ ନିଜ ସ୍ତ୍ରୀ ସସ୍ମିତା ନାମରେ ଜମି ନଥାଇ 1,38,000 ନେଇଛନ୍ତି।
He is not the sanctioning authority. He is not the sanctioning authority, my lord. I have submitted the documents that will be verified.
But no, this thing you can take
time of trial.
Take the defense in the trial.
No, yes.
I can't
He has not whispered.
now.
Page 24,
The
paragraph.
president has not whispered in your one statement with regard to the cheating or what. Audit report does not speak about the, your lordship, kind of the rule 41.
Do you think it is
At this time,
against the
No, Lord.
charge, order of charge?
No, I am submitting my note. But rule 41 clear, rules 41 clear says.
Maybe, but your role, you being a peon, what role you have played, nobody knows. But the allegations are.
That has not been corrected in 161 statement. The very same president was lost the affair and he has said so.
See, next just see. Ajay Shetty statement, last 3 lines. Last 3 lines. Arthabandhu Jena o Minoketan Das, Amo officer, day book and register book ku kuade nei.
How he peon? He is not the record keeper.
You are involved in.
No. How? Yes, peon.
You said that there is no statement against you by any witness under 161.
Yes.
I am reading out right here in front of me.
Affair lost by the president.
Whatever. President might not have said, the other witnesses have said. You are the person who is you are responsible for day book and register book.
Who is to say all these things, my lord.
Anyway, I am not inclined to interfere. What do you want?
I have nothing to say.
You want a
your lordship can visualize.
No, I need not go into anything. I have to see from a case is made out now. Charge is framed. Witnesses are saying that.
On what basis? On what basis charge is framed, my lord? Your lordship can see.
This is FIR allegation
at there.
And next statement.
And that should have been corroborated in 161 statement of the president who has not said anything with regard to the
What is your explanation to see this? Arthabandhu Jena or Minoketan Das, that is you.
No, who
I am an officer, day book and register book.
Who is he? Is not the official, my lord. The person who has
peon can do anything, in the office.
Nah, your lordship can visualize.
For misplacing the file, the peon is that's the allegation.
I am reading out the with regard to final charges. The peon has absolutely no role.
And next witness. Next.
So that is the independent witness.
The Narayan Chandra Senapati also says the same.
That is, they are no connected to the society.
Just see, I'll read it.
They are no connected to the society, my lord.
Arthabandhu Jena, Minoketan Das.
Arthabandhu Jena, every allegation against Arthabandhu Jena.
All the witnesses are saying what to do. 151 statement, all the witnesses, except one.
They are no connected to the society, my lord. Your lordship, I am reading out the rule. Your lordship,
again this witness again, what is his name? Pratima Muduli. Also says the same thing.
Who are they?
Registered book is
my submission is that they are no way connected to the society.
Read one after another. You have placed everything. I have not.
I have submitted whatever documents were there. I have submitted.
Again, another witness, that is Chakradhara Rao. Again, the same thing.
They are my submission is that they are no way connected to the society, my lord. Wow. Only because of the peon I have said so. Otherwise, I would not say so.
He is making much more specific, this witness. Arthabandhu Jena or peon Minoketan Das କୁଆଡେ ନେଇ ଯାଇଛନ୍ତି ଯେ ତାକୁ ଖୋଜା ଖୋଜି କଲେ ମଧ୍ୟ ମିଳୁନି.
If the president's statement is taken into consideration, your lordship,
you have done very good job. You have taken out the record. And next witness, just see another witness.
Your lordship, I am reading it. Officer who will maintain accounts book.
Again says the same thing.
I am placing only rule 41. Officer who will maintain accounts books. It's the committee shall specify which of officers of the society shall keep books of accounts, keep custody of cash and stores, keep other books and registers, and prepare returns and statements. What is the role of the peon of the society?
Peon, you know what is the role. Peon, please. When peon plays the mischief, he doesn't read the rule book. He does something beyond the rule book. I'll simply, will you withdraw or do you want me to write? Then I will have to write all this thing unnecessarily. Because all witnesses are saying the same. The counsel for the petitioner seeks to withdraw the petition to raise all these points at the appropriate stage of the trial. with the petition is disposed of with the liberty estate. Yes. Yes. 17?
17.
Yes.
17, my lord, 2 weeks after, my lord, I will take instruction because the charge sheet is
17 urgent.
20, my lord. There is a error in Vansis case, my lord.
Whenever you file something, some error will be there.
No, my lord, I have.
Every time you do the same.
No, that, my lord, ultimately that will come to my.
You are very casually filing petition.
And
Why I don't know.
one of our associate made it, but I should not tell this court because.
That's right. Yes.
Because all things.
Your office means
I'm
you are
our office, my
judging,
lord. I bow down, my lord.
Yes. What is the mistake here?
Mistake, my lord, once is case number 9 to.
Sometime number, sometime name.
No, my lord, the 11, that number has been transferred from the Jaspur to Bhubaneswar.
You want to correct it?
Yes, my lord.
Correct it.
My lord.
Correct it and thereafter it will be used. Okay. Let him correct. Let him correct.
Well.
Carry out the correction now. Land counsel for the petitioner seeks leave of this court to carry out certain corrections, typographical correction in the petition. The same is allowed to be done in the court and countersigned by.
And the order which was passed earlier, that will.
What earlier?
Then argue, my lord.
The earlier order.
Yes, my lord.
That earlier order. So yesterday's.
My lord, my lord.
I thought it's a new case, another case.
No, my lord.
But the same change is good. And yesterday's the matter was taken up yesterday, and the yesterday's order is restored with the corrections.
Deployed.
So there are two matters, my lord.
Yes.
So for the first matter is concerned, I am appearing for the petitioner. I have filed. Here the father-in-law has filed these applications for quashing of the entire proceeding, my lord. Lordship, initially the FIR is lodged under section 498A 506/34.
The father-in-law's petition.
Father-in-law, my lord.
But you have not implemented the informant.
Informant I have not implemented.
Huh?
But your lordship, here the question is, my lord, 498, not for the quashing on the ground of compromise, my lord. Here, your lordship kindly see, 498 allegations are there against the father-in-law. Accordingly, I released on bail by.
Second petition is by the husband.
One of my friend is appearing.
There this lady is there. The
compromise.
Triveni is there. Okay. Anyway, what is your case?
On behalf of.
Here, though the charge sheet has submitted under section, your lordship kindly see page 20.
Yes. I'm on that. Right.
Father-in-law, my lord.
Yes.
Column number 16.
Come to 23.
Yes. Column number 6, here, my lord, 420, 294, 323, 506, 34. Column number 16. In page 20.
28.
But so far the charge sheet is submitted 376 2N 420 323 294 506 34 against the husband as well as father-in-law. Not a single ingredients are there against the father-in-law. Allegations that with a consensual relationship, the husband has continued the relationship. Subsequently, in presence of both the family members, marriage took place. She stayed in the house of their in-laws, demanded dowry of some more dowry. 7 lakhs they have paid, but they have demanded 7 lakhs more. That is the allegations. But your lordship can even not a single ingredients, even the victim statement.
The charge sheet now, what is the status? They are still married or separated? What?
No, they are married, but they are residing separately.
Yes, Mr. Raghuda, what will happen? Why this father-in-law is in 376?
The
they are married, whatever they are doing, let them do.
First time listed, madam.
But father-in-law, this father-in-law.
376 go, my lord.
Unnecessary father-in-law is entangled. Let them fight out the wife and husband. No father-in-law, no question of prosecuting father-in-law in any proceeding. Even 420, 323, unless the father-in-law has attacked her physically. Is there any allegation?
No, not a single allegation.
Qua father-in-law, I'll say. Husband, let the husband face it.
Husband, my lord,
Age of the father-in-law is 70 years unnecessary because of the fight between the son and the daughter-in-law. Why this old man will suffer? Insofar as the second matter is concerned, I will not interfere.
That case, go to another bench, my lord, since that is not assigned to your receipt to 22, my lord.
22. Let it go to. Okay.
Go to assignment.
First matter, write down. Father-in-law. That is the number. First matter will take father. Report for. The petitioner has challenged. What have you challenged? The entire charge sheet.
My lord, my lord.
The cognizance order.
No, entered charge sheet is under challenge.
No, cognizance order is no, sir.
Subsequently, cognizance has been taken.
Charge sheet.
The charge sheet, two types
You
of
have the
charge sheet.
accused number 1.
Accused number, my lord.
1. Subject material is available against the accused number 1.
Accused number 2 hava.
No, come to page 18. The cognizance order. Peril the fire, CD, 161, shown to the Manama, bail bond, shown to paper available with the case record. For the material on record, I am satisfied that promises a case for offenses shown is well made out. Accordingly, cognizance is also taken. Cognizance is taken.
Your lordship, kindly see the age of the father-in-law has been reflected as 21 years, whereas son's age has been reflected as 30 years.
That's that type.
That is a typographical mistake.
Anyway, look.
In fact, my lord, charge sheet submitted against this petitioner 420, 294, 323, 5034 IPC.
But cognizance is taken.
My lord,
76
that
too.
that is, my lord, I agree.
Ah.
Verify on the case date.
Right.
From the case date.
At the instance, challenging the order dated 16/8/2017, by which cognizance for the offence under section E liquidio, section page 18, has been taken against the petitioner. The case is initiated by the daughter-in-law of the petitioner, arising out of a matrimonial discord with the son of the petitioner. The charge sheet, although the charge sheet is page 20, na?
My lord.
Although charge sheet against the petitioner is submitted under section 420/323/506/34 IPC. However, the court below has taken cognizance for the offence under section cognizance page 18 wala 370 issue notice to implead the opposite party number 2.
My lord. In just now I am implementing.
The counsel of the petitioner seek the leave of the court to implead the informant in the present case as the opposite party number 2. We say he may do so in the court, countersign and so on. So, issue notice to opposite party number 2, newly implemented opposite party number 2. Mr. Bragada accept notice for opposite party number 1. Next, in the intermagnum, the proceeding before the court of so qua the present petitioner is stayed. Qua the present petitioner is stayed. Okay. Insofar as the second matter is concerned, leaves the matter before appropriate bench having the assignment after taking permission form or the honorable chief justice. Take.
Obligation.
32. Date April. April. 22, na?
May I please, Your Lords?
Yes.
My Lords, impugned order is declining the recalling petition for cross-examination of 2 prosecution witnesses.
6 and 17.
6 and 17.
Oh,
My,
show me the, why have you not cross-examined?
my lords, the accused petitioner is a poor one.
Huh?
Poor one. My lords, when the lawyer did not appear on that day.
Where is that? Where is that statement where I can get it? You not filed the statement, it seems.
My lords,
Where is the statement recorded?
Evidence.
Evidence of PW 6 and 17.
evidence I have not.
The
No, order itself reflects that.
No, but I need to know whether these question, what are the proposed question you want to ask? What is the
Totally cross-examine hai nahi. Cross-examination has not been.
Where is that order letter?
My lord, can you see
My
paragraph,
lord,
my lord, page 9.
Page,
Third paragraph, page 9, third paragraph, my lord.
Page 9, huh?
My lord. Perusal of the record, on perusal, it is found that on 24/6/2019, the informant Rama Singh PW 6 was examined. It appears that the defense had declined to cross-examine the witness. Subsequently, as the case record revealed, a petition was filed on behalf of the accused to recall the said witness for her cross-examination by the order 39, dated 21/1/20.
Why have you declined?
This said allowed when once a petition recall petition allowed by the trial court. In spite of the
no, my lords, the accused petitioner is a poor one, tribal people. Se lawyer tankaro se asiki appear koleni.
Application आपण लगे allow hela तापर भी जीवे record करू.
Se Burton lawyer change करजन. Even if my lords, I am submitting a decision after 26 years.
Don't bring all.
But
tell me the facts. Decisions are.
Na एथिरे cross examination
What is the offense? What is the offense?
302, my lord.
302. Give one more opportunity. Why unnecessary getting it?
Cross examine totally hey na.
It's a matter of 302. His right is there.
My
Give
lord.
one opportunity. Only one opportunity.
My lord.
Otherwise, the opportunity is closed.
My lord.
And when is the next date?
Next date, my lords, now available warrant has been issued.
Date kya hoga?
You don't go also to the court.
The available warrant, your lordship made.
It's all right, but why don't you appear in the court now? Okay, I'm
accused statement. The date has been posted for accused statement.
available warrant is issued.
Na hey nahi pora.
Anyway, you go and appear once. Where is your application?
Agya. My lord.
Where is your application? In the application also you have not said. Where is it? Accused is a unmarried belonging to AC. What this 24? What is the reason of your non-appearance? Where you get it?
Page 23, my lords. Petitions.
Yes. What is the ground? Non-cross examination to the PW6 was not intentionally.
District court lawyer has been filed that petition.
But law will not change because of the law. What? You have to give some ground. Nothing is there. The petitioner has challenged the order dated 1/9/2023, whereby his application under section 311 CRPC to recall PW 6 and 17 has been rejected. The petitioner submits that the petitioner submits that the petitioner submits that the counsel for the petitioner submits that the petitioners are the petitioner is a tribal petitioner belongs to a ST community and he is he is unaware of the what ground you have taken now. What will I write? No ground, nothing. Why have you not cross-examined? You tell me what should I write? I'll give opportunity, but what should I write? In the application, nothing is there. What should I have to write something? Why have you not cross-examined? Nothing is there. And doesn't
Communication gap.
doesn't know the differences of law. And for the communication gap, his counsel could not cross-examine the witnesses, could not cross-examine witnesses. The petitioner is facing a trial for an offense under section 302. Therefore, he has a valuable right to defend himself. But taking into consideration the peculiar facts of the present case, I am of the considered view that the petitioner is entitled for a singular opportunity to cross-examine the witnesses. Accordingly, the order dated so is set aside. The petitioner is the trial court is directed to afford a single opportunity to the petitioner to cross-examine the PW 6 and 17. The trial court may fix a date recalling the said witnesses and for subjecting the witnesses to cross-examine by the petitioner. It is made clear that the petitioner fails to avail the singular opportunity afforded to him. No further opportunity shall be given to him, and the trial will proceed according to trial will proceed accordingly. Yeah.
My lords, may I pray further that the accused petitioner may be allowed to continue in his earlier bail. A fresh bail has been directed.
In 311, I will give everything. Go and tell that court.
My lord.
Yes, Anand.
You are not entitled for anything because looking into the prayer, but 302, therefore I am giving it.
My lords, obliged.
Okay. 25. Yes.
The petitioner, the senior advocate for Barcode Bar Association, age of 76 years. The affair has been lost by after 22 years of the occurrence, and found to Annex 1 President given the affair. On 15/7/99, the occurrence. And the affair was lodged 24/6/22, allegation of 465, 471,
Yes.
419, 420. The
76 years, sir.
No, 23 years. 23 years.
After 23 years.
Yes, Lord.
FIR. Well,
Yes.
let us see.
Annex 1, page 10. The column number 3.
On 24/6/2022 is the FIR.
Information.
24/6/22.
6/22.
Yes. Now come to the allegation.
Yes. And the page 12. The informant, the petitioner,
Just see column 3.
Yes, ma'am.
Occurrence of the offense.
15.
Date is
7.
15/7/99.
Yes, ma'am.
To 14.
14 to 2000.
2000. Okay.
Yes, ma'am.
Come on. Let us see the.
You can see the FIR. The informant has alleged, basing upon the power of attorney, the petitioner has sold the property. Kindly come to the paragraph 2. The dated the power of attorney 31/3/98. Got the last paragraph from the bottom.
Read it out. Read it out.
ଦୁଇଟି ଦଲିଲ ସୋ 15/6/1969 ସମ୍ପାଦନ ହୋଇଥିବାରୁ
You are reading which one?
last paragraph page 12 from the top minute.
ଦୁଇଟି ଦଲିଲ.
ଆଜ୍ଞା so dated 15/6/1969 ସମ୍ପାଦନ ହୋଇଥିବାରୁ ତହିଁରେ 31/3/98 କ୍ଷମତା ପ୍ରାପ୍ତ ଦର୍ଶାଇଛନ୍ତି ମିଳନ. Then the property was sold, man. I have annexed the power of attorney that
The property was sold on
23/6/2000, 14 to 2000, and the 2 dates.
23/6/2000.
Yes.
And
when both the dates.
When next date?
That is the 23/6/2000, 31/12/98, and the term on 14/12/2000.
in said paragraph, my lord.
Yes.
Well, then your lordship may come to my lord the power of attorney, my lord.
Which is allegedly
Yes,
fraud,
yes,
fraud
yes,
power of attorney. That is in your favor.
Yes, my lord.
You
Yes, my lord.
sold it.
He said that I have sold it, my lord.
Okay.
You can count to my lord page 30, my lord.
30.
Yes, my lord. Of the paragraph 14.
How many hands it changed?
My lord,
Meanwhile,
the property, my lord, sold to my lord three to four persons, my lord.
Hmm.
And in the power of attorney, two persons have my lord, given the signature. That Padmalochon Sahu and Tadhivaman Sahu, my lord. But one has lost the affair. But to sell, exchange, lease, or dispose of the land under the Bargot PS belonging to the
the informant is the original
owner, my lord.
He says that you have forged this
Yes.
and sold it.
Sold the property.
And how many hands it has changed now?
It has been changed, my lord.
Where is that? Where will I get it?
That is, my lord, in the my lord, paragraph 2, my lord, page 12. এই সম্পত্তিমান যথাক্রমে মিত্রভানু বিশ্বড় রুক্মিণী মহারণা সোমাংশ কনক সোমাংশ হীরালাল প্রধান রুক্মিণী সাহু ভারতী সম্বল মিত্রভানু বিশ্বড়াঙ্ক বিক্রি করে নূতন পটা যথাক্রমে সোমাংশ 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 କରିଛନ୍ତି.
Now it is with whom?
It is them with them, my lord. It is with them.
With whom?
The person who has possessed the property, my lord.
Who all are they?
They are, my lord, মিত্রভানু বিশ্বড় page 12, my lord. Yes, my lord. মিত্রভানু বিশ্বড় রুক্মিণী মহারণা কনক বালা বারিক হীরালাল প্রধান রুক্মিণী সাহু ভারতী সামল মিত্রভানু বিশ্বড়াଙ୍କୁ বিক্রি କରି ନୂତନ ପଟା ଯଥାକ୍ରମେ 300
Yes. Yes, Mr. Goda, what?
My lord, the FIR charge sheet, my lord, only given, my lord.
That's right, but see, in
My lord.
the power of attorney is 2000.
My lord.
Yes,
Sorry,
98,
799.
Lord, so that is there, my lord.
98, my lord, 98.
98.
Yes,
Thereafter, many, it has changed many hands.
And
In fact, my lord, here, my lord, case diary is required as because, my lord, the first time it is listed, my lord. But another thing, my lord, in the FIR at 12, ସେ ସାହୁ କ୍ରେତା 7 ଜଣଙ୍କୁ ନୋଟିସ ଜଣାଇଲୁ ସେ ସାହୁ ବିକ୍ରେତା ତାଙ୍କ ଉତ୍ତରରେ କହିଲେ ଏହା 20 ବର୍ଷ ପୂର୍ବରୁ ହୋଇଥିବାରୁ ବିକ୍ରି ମନେ ପଡୁନାହିଁ ତେଣୁ ତୁମେ କିଛି କାଗଜପତ୍ର ପଠାଇଲେ ମୁଁ ଉତ୍ତର ଦେବି ଆମେ ତାର ଉତ୍ତର ପଠାଇବା ପରେ କୌଣସି ଉତ୍ତର ଦେଲେ ନାହିଁ ଅନ୍ୟ କ୍ରେତା ମାନେ କୌଣସି ନୋଟିସ ଦେଲେ ନାହିଁ.
The petitioner has challenged the order dated 4/5/2023 passed by the where is that 4/5/23 passed by which court?
London SCGM Burgard, my lord.
SCGM Burgard
On 4/5/23, my lord.
under section so and so page 26. FIR came to be registered against the petitioner by one who has by one
Dodhivaman Sahu.
Huh?
Dodhivaman Sahu.
Dodhivaman Sahu. On 24/6/2022. The allegation in the FIR is that in the year where is the power of attorney date?
My lord, that page, my lord.
Page, forget, tell me the date.
Page, my lord, page 32, my lord.
Date
31/3/98.
On 31/3/1998, a power of attorney allegedly paused by the petitioner, and on the strength of the said power of attorney, he has sold the properties of the informant. And next one. The property has been sold many a time between 1998 up till 2022. The FIR is apparently lost after more than 2 decades.
Two decades.
For allegedly having committed an offense in the year 1998. Since in the meantime, the property has changed hands many times. it is difficult to ascertain as to the genuine, as to whether the power of attorney dated 31/3/19 is genuine or not. Genuine or not. Issue notice to implead,
Yes.
you have impleaded.
No,
you
no,
have
no,
not impleaded.
I do it.
Then counsel for the petitioner submit that he seeks permission of the court to implead the informant in the present case as the opposite party number 2 in the court today.
Yes.
He may do so by countersigning so implead.
Yes, sir.
Issue notice to the newly impleaded opposite party number 2 written about within 4 weeks. Next paragraph. Mr. Ragada accept notice. Notice and interim order stay up for the further proceeding. Okay.
Yes, problem.
Okay.
26.
Somewhere it is right. Somewhere right. The petitioner is 76 years.
Yes, sir.
76 years.
And also the advocate of the Bargoda Bar Association.
Huh?
You also advocate of Bargoda Bar.
Don't say that.
No, they get
That makes your case.
Yes, yes.
Then you might have done it.
No, that the fact I'm telling you.
That's right. Being advocate, I had, if you would have said it earlier, I would not have interpreted.
No, I've said, but I have said.
Advocate means he might have done.
No, exact but false allegation.
Might have paused this document and sold it.
How can
Without the
the
knowledge
power
of-
of attorney is in the favor of the petitioner? He can sell the property, my lord.
Anyway, it's now changed hand.
Exactly.
Many interested party might have come now.
Yes, no.
So it will lead nowhere. Even if put to trial, it's
Nothing will happen there. Yes.
Yes.
Application of crossing of the FIR, my lord. Case 26. Case and counter case, my lord.
Yes.
Both the party have appeared. I'm appearing for a last second matter,
All of them are there.
my lord.
Where are they?
My lord, I'm appearing for the.
I am appearing
What are the
for the
offences?
4882.
Huh.
CRLMC 4882.
What are the offences?
Offenses, my lord.
341,
Come on,
290.
Non-compoundable is 294.
And what about the other FIR?
This C76,
Same,
my
same,
lord.
Lord. 506, 294 and other available offences.
What do you say?
If they are settled, then
If settled, nobody is there.
can be. Local
No, physical, not well. I mean, but counsel is present. I got to find out answer.
Counsels are there.
Then lordship,
Lordship, I am filing the affidavit.
Affidavit file করছেন কোন? Where are the affidavits? I'll pass it at your risk. If anything they'll say, they'll tell you only.
376 ଅଛି
ଗାଁ ଗଣ୍ଡଗୋଳରେ ସେମାନେ ତାଙ୍କର ରାଗ ରଗରେ
Right
କରିଦିଅ
off.
ଆରେ 376 କହୁଛନ୍ତି
376.
last second matter.
second FIR.
Then she has to say.
My FIR is 506 only.
We see whatever is fine.
27.
taken up on Monday night.
Adjourn.
Interim order to continue. Interim order টা আছে কিন্তু ଆପଣ ଅର୍ଜନ କରୁଛନ୍ତି
Interim order, how many days you have taken, let us see.
Monday, my lord. May I please your lordship?
You have served
My lord.
the opposite party.
Yes, my lord.
Who is appealing? Do you have any objection?
No, my lord. I have filed a affidavit.
Let counsel for the opposite party files affidavit in response to the petition. Same is taken record. Then counsel for the petition is
Okay,
time.
Okay.
6 time. Adjourn.
My lord, no, my lord. My lord, both the parties has already come. Present also. And they have also blessed with.
Here, my lord, my prayer is to quash the impugned proceeding for the present petitioner, my lord.
Who are you?
My lord, I am arraigned as one of the accused in the charge sheet, my lord. Here, the FIR was lodged in the year 2010, my lord, by the branch manager of the bank, making allegation that some of the villagers, they have, my lord, with the help of the then branch manager, they have produced some fake documents like ROR and other documents, my lord, and they have taken money and they are not paying, my lord. Your lordship may kindly turn to a page
You
11.
are one of the employee of the bank.
No.
Who are you then?
My lord, I am not connected to the bank anyway, my lord. Your lordship may kindly come to page
Then
11.
you might have played a bigger role.
No. ସେମାନେ କହୁଛନ୍ତି ମୁଁ କୁଆଡେ ତାଙ୍କ ସାଙ୍ଗରେ ବି ଲୋନ ନେଇଥିଲି ବୋଲି probably that is the allegation, my lord, but I do not find anything in the. Your lordship may kindly come to the FIR, my lord. Page 11, your lordship will
Come
find.
to charge sheet straight away.
Okay, charge sheet है 2018 रे, after 8 years मतलब I was never an accused in the FIR, nor any statement is there implicating me मतलब in the year 2018 the charge sheet as it appears it was filed I was never knowing that a proceeding is pending where I am an accused 2023 suddenly NBW was issued against the present petitioner. Then I came to know and I applied for the copies and then I am before your lordship. Of course, I had filed a anticipatory bail application which has been rejected on the ground that my status is an absconder. So without going to the merits of the case. Now, if your lordship will kindly turn to page the FIR, your lordship page 10, my lord.
Yes.
Accused, your lordship will find 5 persons have been shown as accused. Mrs. Tori Sabar.
Six of them.
Yes, 6. I'm sorry. 6 persons have been. I was not named in this
Sabar,
FIR.
Dibakar, Tundi, Raju,
Yes.
Mangri, and so and so. Anyway,
Yes.
your name is not there.
Not there.
What
my
are
lord.
the
Your lordship may kindly come to the allegation part, page 11.
Yes.
With reference to the above, we herewith enclose a list of borrowers who availed crop loans from the bank by submitting the record of rights for raising various crops as per guideline. The said loan are payable during post harvest season in the next year.
Repeated their
We have
several times and recovered the loan and so and so. And we replied for Tahsildar Gunpur for certified copy of ROI. And they have given
and
wrong
they have
ROR, taken the money.
taken
That
the
is
money
illegal.
and they have given the list. My lord, your lordship will find page
Yes.
12 and 13.
And when
6
the
persons.
investigation took place, they found that you are also one of them.
My lord, your lordship will find, my lord. My lord, your lordship will find the branch manager's statement. He never utters my name, my lord. Your lordship will find as page 20. He has been examined twice by the police. Page 20 and page 30, my lord.
Yes.
Your lordship will kindly have a glance at page 20. This is the V. Ramana Murthy, aged about 45 years, my lord. Then I am coming to the relevant portion, my lord. His names, Boda, Dibakar Bodapu.
What is your name?
My name is Bodapu Jayadev alias Jayadev Bodapu.
Oh, the manager might not have said, but the other people might have.
Other people, none have said, my lord. The only statement your lordship will find this sweeper of the bank. He makes a statement that I was one of
What
them.
about the Tahsildar?
Nobody has said, my
ROR,
lord.
your ROR.
Nothing has been said. Nothing reveals from the
You
record,
have
my lord.
taken loan.
No, I have never taken loan, my lord. I have never taken loan.
What is your role then?
My lord, I do not know how they have implicated me. I do not know,
So
my
you
lord.
can't be so innocent.
No, my lord, nothing is there on record, my lord, except the statement of
See,
one
allegation is
sweeper.
They have given wrong documents, pause RORs and all, availed the loan. 6 people were implicated. And the investigation, his name also cropped in. What is the allegation against him?
Yes.
Whether he has taken loan by giving pause papers,
right,
wrong papers or not?
Right.
Where is that?
That is the case.
Where is that? So
Yes.
The only statement, if your lordship kindly comes to page 47.
No, he has got from Tahsildar. What is
I have branch manager examine CMO na koileni. Assistant manager examine CMO na koileni. No other staffs uttered my name. A sweeper utters my name along with several others.
ଖାଲି ଗୋଟେ କଥା କହୁଛି ଯେ 41 fake ROR was submitted. 41 numbers of fakes. And this person's name has been named by one Subudhi Narayan. Number 1.
He is the sweeper.
Number 2, Raghulu Binayak.
No, oral statement is something different. Tahsildar has said that the RORs are false.
Yes.
These are all.
Yes, yes.
ସେଇଟା ସେ ଦେଖନ୍ତୁ.
ସେ charge sheet ରେ
Let him show that.
Even
ଆପଣଙ୍କ ସବୁ document file କରିଛନ୍ତି ସେଥିରେ?
in the statement of the manager which you are reading,
yes,
the last 3 lines just read.
ସବୁ statement ରେ ଅଛି ସେ
Recently, I have verified the record
Yes,
of those accounts and I had applied before the Honorable Tahsildar Gunpur for the certified copies of the said RORs.
Yes.
And in this connection, Honorable Tahsildar by their LR number so and so dated so and so, inform to the bank that there are no such khata number in their record
Yes.
for the said loan account. Hence, I inform that so and so.
Says-
Has he taken loan or not? You tell me.
সেইটা দেখার বিষয় যদি লোন নেইছি let them show it.
মানে let them show means you have to satisfy
ମୁଁ
the
ତ
court
satisfy-
that
ମୁଁ ପୁରା
you
ସବୁ
have
ଯାକ
not taken.
ଦେଖଉଛି
But this is the only the document which has been filed. The names of the accused petitioner have been forthcoming. He has
Let us all of three of us let us read and find out whether he has taken loan or not.
Yes, my lord.
Why to
again I am
Yes, my lord. Your lordship,
argue among ourselves? Let
my
us
lord,
see
the competent witnesses, my lord.
Not there.
এটা বলিয়া দরকার নাই
The competent witnesses are the manager, assistant manager,
Oral witness will not help.
Yes.
You show me whether you have taken loan.
ওদের আগে দেখা যায়নি my instruction is that I have not never taken loan, my lord. If somebody has my lord manipulated any document and if my signature is there, my lord, let them show it, my lord. That is nothing on record, my lord. I have brought all the documents before your lordship, my lord.
Evidence you have
my lord
Charge sheet be nothing reveals against me, my lord. Only says only the charge sheet reveals that I, along with others, I am an absconder. So, my lord, submitted charge sheet against me. Your lordship may kindly come to page 89.
Write down. Petitioner is challenging the order dated.
Order nahi, proceeding ta.
Petitioner is
Purpose.
challenging. Petitioner has filed the present petition under 482 CRPC seeking quashing up for the entire criminal prosecution initiated against him. Wide GR case number 91 of 2010 pending in the court so and so. Take it. Mr. Mishra, land counsel for the petitioner submits that in the FIR, the allegation is there are 6 in the FIR. His name was not mentioned. It is alleged in the FIR that 6 persons have availed loan from the bank by submitting fake RORs and other land documents, loan documents. After investigation, the petitioner has also been charge sheeted. Mr. Mishra, land counsel for the petitioner submits that he in the entire record produced by the prosecution, there is not a single whisper regarding the fact that his client has availed loan from the bank by submitting the fake ROR. It is only an isolated statement of one of the sweeper of the bank who has
other statement.
I'm recording sweeper of the bank who has implicated him. Mr. Maharaja appears for the state and submits that there are except barring there are many other evidences which are staring on the face of record against the petitioner. He further seeks time to ascertain ascertain the facts of the petitioner, whether the petitioner has availed loan or by submitting the fake documents or not. In order to obtain instruction, the matter is now posted to the report date. 1st February, 1st March.
Yes.
You get only, you tell me whether he has taken loan.
Yes.
If he has taken loan, he is in. If he is not taken loan, he is out.
My lord, what happens, my lord? Let him bring the record, my lord. Let him show that I have produced the document. They have to prove that I have produced the document.
If you are a beneficiary, taken the loan, then
what I beg to submit, my lord. My lord, out of record, I am submitting what has happened, my lord. In fact, my lord, the then branch manager, who is also an accused here, my lord, he has manipulated everything, my lord. The documents, everything, he has taken all the benefits, my lord. Now these poor people,
the money might have come to you.
no, I have never received a single pie, my lord.
So that is your defense. But it might have come
No,
to your
that
account.
is, that is my defense.
shown
But
after all.
what is the material with the prosecution?
That will see. The only question is, the allegation is, by producing fake document, loans were availed.
Loans
And
are
so,
availed, my lord.
availed
Who
is
has
not,
availed
they
the
are
loan?
accused.
It is not
If
known.
you are among them, then you have to face the trial.
If I am a
If you are not-
beneficiary of that, my lord, then I can be very much
Whatever you have
prosecuted.
said, I have recorded. Let
Yes.
us see what he says.
ବ୍ରାଞ୍ଚ ମ୍ୟାନେଜର ସବୁ କରିକି ଠକି ଧରି ପଳେଇଲା ସିଏ ବର୍ତ୍ତମାନ ସବୁ
ମୋର account କୁ ତ
ପୁଅର ଭିଲେଜ ନାଇଁ ଆଜ୍ଞା ଆମ ଆକାଉଣ୍ଟ କୁ କିଛି ଆସିନି
କ୍ୟାଶ ନେଇକି ପଳେଇଲା।
ସେ ସବୁ ଧରିକି ପଳେଇ ଯାଇଛନ୍ତି ଆଜ୍ଞା ସିଏ କଣ କରିଛନ୍ତି ତାଙ୍କ ବ୍ୟାଙ୍କ
ଲୋନ ମାନେ it might have transferred to your own account.
ସେତେବେଳେ ଆଜ୍ଞା ଆକାଉଣ୍ଟ ଫାକାଉଣ୍ଟ ଟ୍ରାନ୍ସଫର ହଉନଥିଲା ଇଏ 2010 କଥା
ସେମାନେ ସବୁ ଆଣିକି ଯୋଗେଇଲେ ଫେକ୍ ଆରଓଆର ଯୋଗେଇଲେ
କୋଉଠି ସେଟା ଅଛି
ବ୍ୟାଙ୍କରୁ ଟଙ୍କା
where from you get that
ଯୋଉ ଆରଓଆର ଗୁଡା
କିଏ ଆରଓଆର ଟା ପ୍ରଡ୍ୟୁସ
That is what he will say.
ମନେ କରନ୍ତୁ ଗୋଟେ ଫେକ୍ ଆରଓଆର କିଏ ଗୋଟେ ପ୍ରଡ୍ୟୁସ କରି XYZ କିଏ ଗୋଟେ ବୋନାରେ ଲୋନ ନେଇଗଲା so I will be prosecuted my lord this is a very
Whatever.
my lord poor people they are unnecessarily suffering my lord this way.
Somebody has taken or somebody is not taken, that's the matter of trial. At this stage,
That
I
is
can't
correct. That is correct.
get into the record to find out
But
whether
there
you
must
were
be
cheated or you are whatever.
there must be something on record to suggest that yes I am the beneficiary I have got the money.
The coordinate bench has rejected your.
Yes.
No, no, ସେଇଟା anticipated bail ଟା reject କରିଛନ୍ତି solely on the ground that my status is an absconder, my lord. The honorable court said, my lord, when I wanted to produce all these materials.
Bail now?
ये कॉपीटा नहीं है
नहीं नहीं परा bail नहीं ସେଠି ତ ମୋର problem ହଉଛି
ये
ସେଠି
कॉपीटा
You are entitled to bail, you will get it.
your lordship may pass that order, my lord.
And how can I say that you are?
Your lordship may say that only thing, my lord, if your lordship can say, my lord, I'll surrender and parity on parity, my bail application will be considered because all others have been.
That is his case.
yes
ସେତିକି କରିଦେଲେ ଆଜ୍ଞା ମୁଁ ପଳେଇ ମୁଁ I am ready to face the trial. The whole difficulty is, my lord, if I surrender, I'll be immediately taken to.
I'll record your statement and go and take appropriate remedy.
Remedy by maintaining parity, let them dispose of the bail application, both the courts.
Obviously, you have
on this side.
all other accused persons are on bail.
ସମସ୍ତେ ଆଜ୍ଞା ବେଲରେ ଅଛନ୍ତି ଏଇ ଯୋଉ ଆବସ୍କଣ୍ଡର କୁ ଛାଡି ଦେଇକି ବାକି ଯୋଉମାନେ ସବୁ ଆରେଷ୍ଟ ହେଇଥିଲେ ସମସ୍ତେ ବେଲରେ ଅଛନ୍ତି ଆବସ୍କଣ୍ଡର କେତେ ଜଣ ରହିଛନ୍ତି ସେମାନଙ୍କ ନାଁ ସବୁ ଯୋଡା ହେଇଛି
You are
ପଛରେ
entitled to bail.
yes
Get
ma'am.
it. What is it?
that is what your lordship may dispose of the application so that I can go on bail and face the trial because I know I will be acquitted, my lord, because nothing is there on record to prove that I have received a single fine.
Find out a way to give some relief. That's all.
your lordship may give any relief
If he has
Only-
now
that is your
ସେତିକି ହେଇଗଲେ ବି ଆଜ୍ଞା ମୁଁ ଫେସ୍ କରିବି ଟ୍ରାଏଲ କିଛି ଅସୁବିଧା ନାହିଁ ଆମେ
ଆସନ୍ତି disposable ଯାଏ କୋର୍ଟ କେସ୍
Systems trial କିଛି ଅଛି tribal by offense will be ଅଛି
No, Maharaja, Mr. Maharaja submits that the attempt of the petitioner to get the concession of pre-arrest bail by filing ABPL number 3562 of 2023 did not get favor from the court. And the coordinate bench by order dated 24/4/2023 has rejected the indicatory bail application. Application. The perusal of the order indicates the said order indicates that the coordinate bench has rejected the application on the ground that the petitioner was an absconder. Full stop. Next order. The Mr. Mishra submits that all other accused persons are on bail.
who are arrested
Are on bail, except the Except his claim, except his.
No, no,
No, no.
except 22 absconding accused.
Say,
Except the, except
absconding
the
accused
accused
person.
persons, those who have absconded.
Yes.
Full stop. Mr. Maharaja appears for the state and submits that although in the FIR, 6 names was initially found mentioned, but in the investigation it was found that as many, how many of them?
Total 22 accused persons.
As many as 22 accused persons have availed loan from the bank by producing fake documents, fake.
Total, my lord, Your Lordship, may I kindly correct it? 47 accused persons.
47. Fake
47.
documents.
Accused number
Fake
9.
documents. Number कोई देखो for fake document. Fake document. It is fake documents. Therefore, the petitioner is not entitled for any relief in the present case. The petitioner, Mr. Maharaja further submits that the present petition is nothing but a bail application in disguise. Bail application in disguise. Next paragraph. Mr. Mishra submits that during investigation he has not received any notice from the police. It is only the investigation not to police, and he had no knowledge regarding the case being registered against him. Case being registered against. It is only the branch manager of the bank who had manipulated all the documents and involved and instigated the present petition. Perusal of the record reveals that there are many evidence which has come on record against the accused persons. At this stage, the court may not dwell upon the merits of each individual accused, merit of the case of each individual. Suffices to say that the petitioner may face the trial to suffices to say that petitioner may raise all these points at the appropriate stage of the trial, and seek parity with the other accused persons insofar as grant of bail is concerned. At this stage, petitioner Mr. Mishra seeks to withdraw this petition to avail his remedy under law on the ground of parity, as well as on merit, as well as the petition is disposed of with the liberty as stated. I have recorded everything.
Direction that is
47 accused persons, 37 Your Lordship.
37.
Your Lordship. Only thing Your Lordship may.
I think I have done more than what
I can seek parity, my lord. Your Lordship may direct the court below will dispose upon by maintaining parity. Nole kon hobo ki nole se debbe nahi age mo jodi ye puni bhitar rahi jiba innocent people will go inside, my lord. That is the whole difficulty.
It's not so innocent, but I have recorded so many things. I'll mold it little
nahi seita khali kar do.
I'll try to mold it little bit.
Mu seita kohuchi mold
Try to understand the limitation of the 480. I can't anticipate bail you got rejected by some court. I'm as if I'm sitting in
got rejected on the ground that because merely because he was an absconder. The honorable court said that you move an application under section 482, but here I cannot do it.
And you are projecting as if your client is so innocent, but they are not. That also you know.
ମୁଁ ସେଥିପାଇଁ ତ ହଜୁର କହିଲେ ଯେ ସେ ଟ୍ରାଏଲ ଫେସ୍ କରିବା ପାଇଁ ପ୍ରସ୍ତୁତ ଅଛି. Let him face the
I have
trial.
recorded. I'll try to mold it.
ସେଇଟା ଖାଲି କରିଦେଲେ
try
he can get the benefit, otherwise my lord.
They should get bail. That's my.
Yes, my lord. That is why
they face the trial and whatever.
ସେଇଟା ଖାଲି ଡାଇରେକ୍ସନ ଟା ଦେଇଦେଲେ ତଳ କୋର୍ଟକୁ.
What is the range of loan amounts?
30,000 ରୁ 50,000 ଆଜ୍ଞା.
ମାନେ per head.
Per head 30,000 ରୁ 50,000. and the prosecution
money ଗୁଡା ନିଆଯାଇଛନ୍ତି ନା ତେଣୁ ସେଟା
That's right, but see, the other side you they see.
ସେ ଯାଆନ୍ତୁ
They are-
ଟ୍ରାଏଲ ଫେସ୍ କିଛି ଅସୁବିଧା
ଆଉ
I
ଗୋଟେ
just try to mold it.
investigation is also defective. ସେମାନେ କହୁଛନ୍ତି 41 ଟା ଯେ fake error
And you are bound, you know that you are
accused
bound to.
37
you are
ଦେଖିଛନ୍ତି
bound
ବାକି
to be
4 ଜଣ
acquitted-
କୁଆଡେ ଗଲେ?
Bound to be acquitted in this kind of evidence.
Obviously, my lord.
So only the
But
bail.
the whole difficulty is that if he is arrested, my lord, poor people they cannot.
They'll get good treatment there. Poor people will get good.
ନାଇଁ ଗୁଡ୍ ଟ୍ରିଟମେଣ୍ଟ ଯେ ତା ଫ୍ୟାମିଲି ଗୁଡା ମରିଯିବେ ନା ଖାଇବାକୁ ପାଇବେନି ସିଏ ତ ଗୁଡ୍ ଟ୍ରିଟମେଣ୍ଟ ପାଇଯିବ କିନ୍ତୁ ଫ୍ୟାମିଲି ମରିଯିବେ ଆଜ୍ଞା
I'll just see.
ୱେଜ୍ ଆର୍ ନଟ୍ ଡେଲି ୱେଜ୍ ଆର୍ ନଟ୍
I'll just see what. Yes. 32. Yes.
and your lordship I will surrender within a specified time.
Oh, you surrender before 7th of March. 7th
Yes.
ଆଉ ଗୋଟେ ୱେଲଫେୟାର ଫଣ୍ଡ କୁ ଦେବେ
Welfare fund 30,000 କଣ welfare fund ଦେବେ?
ସିଏ ନେଇଛନ୍ତି ନା ନାଇଁ ଜଣା ନାହିଁ ମାନେ
Now you think of doing some welfare to them. That, yes.
Oh,
Yes.
my lordship. My lord,
Which one?
32.
Yes.
My lord, have a glance to the annexure 1 of the FIR, my lord.
Hmm.
FIR was laws 379, 447, 120B, my lord. Then 345 E Explosive Act and
Essential commodity, what is that? Yes, what is that?
Explosive, my lord.
Explosive.
My lord. Substance Act, my lord. 345 and 51 OMCC Rule 2016. So, lordship may see the FIR page 8, my lord.
18.
8, page 8, running page 8.
Yes, yes.
Third paragraph, my lord. During course of inquiry, it is revealed that the lessee.
What do you want in this petition?
Well, question, your lordship, have a glance to this paragraph.
Okay. During the course of inquiry.
Yes, my lord. This Pratap Prasad, this petition, knowing fully well that the plot number 05 has been leased out to him for the purpose of quarry operation, but he deliberately, with dishonest intention, has been extracted minerals from plot number 62. That is the allegation. My lord, 62 has been allotted in my favor. I am doing this quarry last 20 years. So, lordship may see that.
Come on, let us understand now. Who are you? What is your name?
My lord, Pratap Prasad, the present
You
petitioner.
are the Pratap Prasad.
Yes, my lord.
During the course of inquiry,
Yes.
it reveals that the leasee, Pratap Prasad,
Yes.
knowing fully well that the plot number phones has been leased out to him.
My
For
lord.
the purpose of quarry operation, so and so deliberately.
Plot number 62, khata number 7. Only.
Plot 5 was allotted to you. but
Yes, that is their allegation. That is their allegation. For last 20 years, prior to that, other person was doing that quarry.
62 plot you are operating. That's
Yes,
it.
my lord. जो 5 plot ta, that is a, your lordship, I am coming to that. Then Mauja, what you got 9.
ଆପଣଙ୍କର କେସ୍ କଣ ଅଛି 20 ବର୍ଷ ହେଲା ମୁଁ ଚୋରି କରୁଛି ତ
ନାଇଁ ମୁଁ ସାର୍ ମତେ ସେଟା ଆଲଟମେଣ୍ଟ କରିଛନ୍ତି ଅନ୍ ଲିଜ୍ ମୋ ଆଗରୁ ଆଉ ଜଣେ ଥିଲେ ସେଥିରେ
62
20 ମସିହା ମୁଁ କରୁଛି 2000 ଆଗରୁ ଆଉ ଜଣେ ଥିଲେ ସେ ଜାଗା ଉପରେ ଆଉ ଯୋଉ ପ୍ଲଟଟା ସେ କହୁଛନ୍ତି ମତେ ଦିଆ ହେଇଛି ସେଟା ହଉଛି ଜଙ୍ଗଲଟା ପତ୍ର ଜଙ୍ଗଲ that is there they have reflected or see that it is pertinent to mention here that the area of plot number 62 where from the lessee has been illegally extracting the minerals from the quarry is about 9.72, whereas the area of lease out area is 1 yes,
half a kilometer distance.
yes, my lord, half a kilometer. And the dishonest intention to extract minerals from plot number 62 of Pratap Prasad is patent. It is also revealed that your lordship next
On the spot.
page 9, your lordship page 9.
Now you read it on the spot verification.
Yes.
Same petty cross.
On the
raised and
it is also revealed that I think is some paddy crops. जो कहउछन जोटा हमको अलॉटमेंट है that is paddy crops have been raised over there is non existence of any quarry. मु तले पैसा देकी ऑक्शन ने नउछ आज्ञा मते सेटा जोटा देले रेवेन्यू वाला मु सेटा 20 वर्ष ला करूची ता आगु आउ जने भी करथले
आपको जहा अलॉट हेची ताइरे तो पेडी होची आ गुडे हाफ एंड हाफ
से कहउछन आज्ञा रेकॉर्ड हजूर मते जोटा देइथिले सेमान जोटा पोजीशन ता आरआई दियंती तहसीलदार दियंती मते जोड़ा देले मु सेटा खोली 20 वर्ष भीतर से माने देखिले नै लास्ट पार्ट को से मते धरले लॉर्डशिप में सीधा
आपण जगह आपको अलॉट हेची तारे पेडी चलची
इट्स अ डेंजरस
आपण जाके अन्य जगह जाके आरंभ कर देली
आमु हजूर 20 वर्ष हलानी मु करची मो आगु आउरी 20 वर्ष हला की करथला देन योर लॉर्डशिप में सी दैट Page 9. Page 9, last portion. It is even that Sri Pratap Prasad has been going on taking lease on plot number 5 since last 2 decades. Your Lordship may see that. What I am submitting. And has been illegally
That's
extended.
right, that's the only thing, that's the allegation.
Then
5 is allotted to you.
Yes, my lord.
Their paddy is growing. You have gone to 62, half a kilometer started
Yes,
extracting. That's the allegation.
That is the allegation. Who has given my possession to that extension, my lord?
They will also be co-accused with you.
Yes, no. That is your challenge before your Lordship may see that. Last paragraph I am just pressing. It appears that Pratap Prasad in connivance and conspiracy with the government officials have been doing such illegal act. Otherwise, the aforesaid illegal activities could not have been perpetrated for such a long period. Since the Pratap Prasad has been extracting minerals from plot number 62 belonging to Patra Jungle for such a considerable period continuously, the involvement of forest officer, revenue officer cannot be ruled out, and their role appears to be dubious, my lord. And then Lordship may turn to charge sheet, my lord. Now, my lord, the offense 120B, they have, my lord, discharged and submitted. The Lordship may see that charge sheet under section 379, 447. Only one person at this petitioner has been charge sheeted. That is under challenge before your Lordship.
Now you will also may kindly see the conduct of the accused. But there are 2 applications, same application has been filed before this one, but no certificate has been given. Both the application has been disputed. CR elements number 1619 of
that is separate cause of action for release of that year. That has been allowed.
CR elements number 106 of 2021.
My lord, that is a separate issue, your Lordship. My account has been seized. Challenging that order, I have come before your Lordship, and that has been allowed by this honorable court.
Apart from that, then again I am coming to the merit of the case. During investigation, it reveals that the accused Pratap Prasad had been operating stone quarry illegally in plot number 62, Khata number 13 of Mauja, Mochikanda, Bisra, Tahsil in district of Sundargarh since last 15 years. During my interrogation, neither the present Tahsil staff nor staff of RI office could give any satisfactory answer as to how the accused was not prevented ever since his operation from doing such illegal business. They further added that they were afraid of visiting the spot area as the area was dominated by Maoist elements. Whatever verification was necessary, they used to do that in the office going through the records available. So this is very dangerous place, and this is very, so obviously this would happen any such discrepancy or any defect. So he has to face the trial, and
in a fair, they say that is conspiracy.
But the fact remains that 62 plot you are doing.
My lord, I am doing.
Your defense is, I have been doing since 20 years.
No, I am not saying so. My lord, that possession is given by the Tahsildar and the RI.
That is your defense.
That is.
How can I elucidate all these things from this record? Who has given you?
Yes, I give that, because that is the agreement, my lord.
What are the admitted facts? Admitted facts is plot number 5 is given to you. That is an admitted fact.
That is the prosecution story, my lord.
What?
The
lease,
because the agreement is
documents are there. Lease is given to you. Plot number 5. Plot number 62 is half a kilometer distance from plot number 5. The plot number 5 there are paddy, and you are going half a kilometer away and doing quarry since last 20 years. Your defense is, since I have been doing it since last 20 years, nobody. I am doing
prior to my lord.
So who is given? Who is involved? And all these things. 319 is also there. Don't worry.
Yes.
Your lordship,
will come.
No, my lord, I have got the other document. I will file an affidavit. Because there was an agreement signed by the revenue authority and the myself.
And the region has not been mentioned why he has not disclosed the earlier application.
Earlier application is different angle, my lord. For release of that account, that has been allowed by the Honorable Court.
Now he is seeking time because he knows.
No.
No, because I give that where the wind is flowing. Simply adjourn.
Yes. Then I will give that. Oh yes.
Simply adjourn.
Yes.
Because you know the wind flowing from a different direction. Simply adjourn. Let him try somewhere else.
Yes.
But you don't have a case. Better you
have a case because I have the document.
You are on bail.
Have bail, my lord.
Why don't you try?
My lord, investigation says how the other officers are those who have given the possession, my lord, and signed the agreement. Unless until well, last 20 years, then prior to that, another person was
390, 390.
reason টা already mention ହେଇଛି ତାଦେହରେ ସେ reason ଟା ମୁଁ I have read out
Moist area କି ଯାଇ ପାରିଲେନି
କିଏ ଯିବ
ଆଜ୍ଞା ମାଓ ଷ୍ଟେଡିୟମ ଲିଜ କେମିତି ଦଉଥିଲେ ସେ?
ଆପଣ ଚଲେଇଛନ୍ତି moist area ରେ ଏକ୍ସଟ୍ରାକ୍ସନ କରୁଛନ୍ତି ଆଉ କଣ? That's the problem.
ସେଟା ପୁଣି time to time measurement
319 is there during trial if anybody is involved.
ଯଦି କିଛି other evidence ଆସିଲା offense will be added.
FIR ରେ ସେ କହିଲେ other officers are involved. ଯେତେବେଳେ ଚାର୍ଜ ସିଟ୍ କଲେ ତାଙ୍କୁ ସେ omit କରିଦେଲେ.
That's a good point for you to
Yes,
get acquitted.
that's why I have come before your lordship. That is the point.
No, acquittal. Not for for acquittal good. So like disposing
No.
giving
Because I have some documents so that I can file it. What my lord friend has suggested that other CLMC.
If you can show me, if you can show me one document.
Yes, my lord.
Right here I'll pass it. Show me one document.
My lord.
I'll put it tomorrow. Come with document, need not file. You show me that 62 plot is given to you. Handed over.
That's why I what
if 62 plot is handed over to
because
you,
he is from Raulkela. That's why that is correct. Yes.
That position is given to you.
Yes, exactly.
Right here I'll pass it.
Yes.
Tomorrow?
Tomorrow, Hajur, he is from Raulkela. He will come with the records. That's why.
Simply list it down. You come with that document?
Yes.
And even if I am adjourning it, you come with document, mention it.
Yes.
For me, I'll pass it.
Oblige.
Simple.
I have the document, your lord.
Get that document.
Yes.
If position is
Yes.
given to you,
Yes,
in
exactly.
62 is concerned,
Yes.
then you have a point.
Yes.
You have a point. Since you have given the position to
Yes. Unless until I got the possession, how can I?
you show me that
possession region
Yes, I will give it.
show me that.
ଦେଖିବା
Okay, adjourn it.
who is our con position
Mark first week. First week of March.
Oblige.
And if you get that document earlier also, you can come and straight away mention.
I can mention.
I'll take it up. No problem. Okay.
33 my lord. The entire transaction is civil in nature, but it has been given a color of criminal case, my lord.
Yes.
The fact of the case, my lord, Annexure 2 is my cell deed. Here, my lord, the one vendor is Sadanand Tarasia. He has sold to me. Let's see, may kindly have a glance to page 41
Yes.
of that annexure, my lord.
What is the stage of the investigation?
Investigation charge sheet has not been filed, my lord. I'm praying for quashing of the proceeding, my lord, because I have been victimized in this case, my lord. The facts remaining like it's a complaint case. The fact is that when I have purchased, this is a registered sale deed. I have purchased the land from one Sadanand. Sadanand has produced a encumbrance certificate of 20 years and his Aadhaar card page 43. His voter ID card is 44.
Sadananda is your vendor.
Is my vendor.
You purchase it.
Purchased and sale deed was issued. After issuance of a registered sale deed, what happened, my lord? The complaint case is filed by the informant that he has alleged that my deceased father has purchased the land by virtue of a sale deed.
From Sadananda.
Sadananda. But the record doesn't show anything in the ROR still in the name of Sadananda. Thereafter, he has alleged in the complaint case.
ROR is also in the name of.
Yes, sir, that is page 45. Page 45 ROR in the name of Sadanand, my lord. What happened, my lord? After sale deed was registered and issued in our favor, thereafter, he has filed a complaint case. My deceased father has purchased this piece of land
From Sadananda.
from deceased Sadanand, who has already been died in in the year 88. 1988.
This sale deed in your favor.
My lord?
This sale deed is in your favor.
Yes, the present sale deed annexure 2 is in my favor.
That is on.
That is annexure 2, my lord.
No, date you tell.
Date 2023, my lord.
23.
26/6/2023.
By that time, Sadananda died already.
Because in the before the register, that Sadanand has produced the entire document, Aadhaar card, and the encumbrance certificate.
According to you, Sadananda is impersonated.
Yes, but we have been victimized. We have been cheated.
Where is the Aadhaar card?
Other page 43, let's see. 43. And 44 is the electoral card, my lord.
Sadananda, Sannapo.
Dambur Tarasia.
And 45 is the cell deed still in the name of Sadanand, my lord. So it has been verified by the registered, sub-registered Cuttack, my lord.
Bail granted.
Bail granted to petition number 1 already.
You'll also may kindly say I have given a order. You'll also may kindly give. It's a long order.
Another,
What do you want to show?
Lordship may see, another writ application has been filed. I'm coming, my lord. A writ application filed, that is page, informant, page 72. There they are claiming for question that set aside of the cell deeds. So my humble submission.
Writ petition, cell deed setting care.
They have filed. They have filed. I have not filed. I have been issued notice. I have appeared, my lord.
How writ is maintainable?
I don't know. They have filed.
They have to file a suit for declaration.
Exactly. Both the cell deed is exist now. They can go before the civil court. Now they have filed a complaint case and now harassing. This is my case, my lord. I have been victimized.
A combined order has been passed by this honorable court in 3 bail applications consecutively. Lordship may kindly say long informant was appeared and everything has been discussed. Everything has been mentioned.
Same
thing.
Same gentleman.
Same gentleman. That certificate has not been given. Even though, my lord, the order has already very clear.
He is Chandan Kumar Jana.
Yes, in
there are 4 persons.
4 persons.
Linka.
Umesh Ranjan and Chandan Kumar. Umesh Ranjan and Chandan.
They are co-accused.
They are co-accused. They are also petitioner here.
Before your
Because that time we have filed a, I am not the lawyer.
How to get out of it?
The order already.
Because the entire transaction is civil in nature. Both the cell deed are exist, my lord.
Civil nature, see, if you impersonated, if
I am not impersonate, my lord.
The Aadhaar card is suppose manipulated, you are bringing someone else saying that he is.
That police can say, my lord, because we don't have any role because we have gone to the.
That is the criminality. See, it may be civil nature.
That is exactly the record will show, my
Crime is
lord.
not the land. Crime is the impersonation.
Impersonation, we have not done, my lord. Because some person has come, as land is vacant, some person has come and shows the document, we have verified in the net, if it is okay, then we have go for a transaction. So
It
we
says
have been.
that whether a person is alive or not cannot be verified referring to the voter ID card or Aadhaar card, etc. Or rather, it would be reasonable to suppose that the petitioner would make further inquiry about the identity.
And 88 he had purchased, that cell deed also valid or not valid, we don't have knowledge, my lord.
When the voter ID card and Aadhaar card and the sale deed dated so and so mentions the payment of considerations, but they already.
We don't have occasion to know the fact that he has died in the
The
meantime.
amount is actually paid. All these facts from office shows that complexity. Have you apprehended this person who has filed these Aadhaar card and all?
No. They have filed, they failed their anticipatory bail and we are still
investigating.
Yes. We are still in apprehending the accused person. We could not able to apprehend them. They are absconding.
These are allegations are very serious matter.
Serious matter, we have no occasion to know, my lord, because like vacant land, somebody has come.
This court, while rejecting the bail application of other people, have said that the Aadhaar card and I card, the voter ID card are not the conclusive proof of
not other minor
fact that the
And that ROR also.
These petitioners.
That's right.
ROR also.
How can I supersede this order?
That is one fact.
How can I supersede?
My respectful submission that I have been a victimized in this case.
Whatever may be, there is an order staring on the face.
Now after 88, the son is claiming.
You have not followed what I'm saying.
I understand.
There are 2 proceedings which are pending in this court. First proceeding, your bail application is rejected. There are findings.
Yes, sir.
If I interfere, I have to upset this finding which I have given, which I can't do. First. Second, there is a writ petition, wrong, right, whatever. Notice has been issued, you are facing that writ petition.
Yes, ma'am.
If I pass any order saying anything, that will influence that writ petition also. So therefore, I will not do. As simple as that. So simply I am adjourning it. Wait till.
We'll tag it to the writ application.
Simply adjourn.
All right.
March. Yes.
My limited prayer is time bound period for the court below. As per the settled preposition of law, the Lorraine Council lower court is neither taken any step against the accused person. This charge sheet has been submitted since 2021.
You are informant.
Informal, Your Lordship. Is a death case. The charge sheet has been submitted under section 279 9304A IPC.
31st December 2020.
Though accused has been.
There are only prayer, my lord. Your Lordship can turn to page 4, clause A. I am reading, my lord. From that, learned SDGM Kendrapada has failed to consider situation of the informant, younger brother of the deceased, and dependents of the deceased. After receiving the summon from the court below, the opposite party number 2, though appeared on date 33/2021, but constantly taking time with the intention to deliver the case.
How can the 482 code will control the
Control.
If somebody is moving application, somebody is doing that, I'll say that. If they have a legal right,
I'm-
they'll do it.
Your Lordship, kindly see
Only your Lordship can give relief that speedy dispose of the
ground number
trial.
3, Your Lordship.
That can
I
your
have-
Lordship can.
It's very easy for us to say speedy, but the court has its own pressure.
Your Lordship may not fix any date.
But time
not
frame,
fix any
Your
date.
Lordship,
Only
humble
as
pray, Your
expeditiously
Lordship,
as possible.
time may be
That's
bound for
See, the
disposal of
accused
the
person-
trial.
see, the accused
Though
One
accused
minute.
person is,
1 minute, accused persons are appearing, but they are seeking time by
but
moving up.
frequently taking time
Can I
and
control
court allowed
them?
also.
Can I control them sitting here?
No, Your Lordship. Kindly see, see.
I will see
clause.
as expeditiously as possible.
Yes.
Yes, Your Lordship.
Okay.
That's
I'll not
it.
fix any
That's it.
outer timeline.
Your Lordship.
That's not fair for me to do.
That is enough.
Learned counsel for the petitioner. And the petitioner is the informant in the FIR number so and so. FIR number so. The petitioner seeks indulgence of this court. Indulgence of this court for direction for expeditious disposal of the trial. Expeditious disposal trial. The charge sheet was filed on charge sheet
Charge sheet
in case
33
filed on 31/12/2020 under section 279 and 304 A IPC. And counsel for the petitioner, Mr. Maharaja, appears for the state, submits that although the accused persons are appearing, but they are seeking unnecessary adjournment, aiming at prolonging the trial. Needless to say that expeditious, fair and expeditious trial is the mandate of law. Therefore, it is expected that the trial court will do well to see that the trial is disposed of as expeditiously as possible. Yes.
Obliged.
We'll do it after.
Yes.
Any mentioning?
35 madam.
Detail padega.
Notice.
Notice.
Only notice, my lord. 35 only notice.
Only notice.
My lord, the opposite party also appear to compromise the matter, my lord.
Compromise.
My lord.
So notice has to be issued.
Yes, ma'am.
Issue notice to the.
But my lord, opposite party.
My lord,
I'm appearing for the informant, my lord. I'm appearing for the informant, my lord.
There are some personal affairs matters are there.
Your Lordship can
do
take.
it.
Item number 55.
Personal appearance is there. So we'll take it up.
Yes, item 61, I find for adjournment.
Which one?
55.
Why 55? Entry model is there.
Lord, in item number 56, will your lordship take it up after lunch?
Let
me finish up first.
Item 61. Petitioner counseling.
Personal affairs.
Item 61, I pray for.
Are you enjoying entry model?
No, I am.
They want adjournment. They want that you should keep on enjoying it. Let it be the adjourn. Entry model to continue.
For an adjournment.
One after another. He is saying something.
Lord, in item number 56, will your lordship take it up after lunch?
Huh?
After 1 week.
You are asking for adjournment?
No, my lord, I'm not. I'm not.
Yes.
I'm not.
Item number 45. 45.
Yes.
Praying for an adjournment.
Is the fresh matter?
Lordship.
Adjourn.
Defect.
Yes. Lordships in item number 66, my learned.
Yes, yes. 66.
56, your lordship.
56, yes.
My
That
lord, in
case,
item,
Master, my lord, Mr. HS Mishra prayed for time. Earlier, the informant engaged another council. Now, he changed the council and Mr. Mishra in the first hour approached for adjournment. For that, the university asked the court master to point out the same.
my lord,
I have
this,
mentioned that one advocate, if they want
my lord,
adjournment.
my lord, I have an objection here. Item 56, this was substantially heard by your lordships. And
I don't know. I don't remember it. But what exactly you want? You want an adjournment?
no, my lord, I do not want an adjournment in this matter.
So why are you mentioning then? No,
No,
my lord.
someone mentioned that
opposite party. Change his council. Let it come then.
Yes,
we'll
yes.
see.
Data would-
Let it come at 2 o'clock.
Yes, yes.
ବାରଶହଟା ପକେଇଦେବା ଆମ ପାର୍ଟି
Sir, I obtained the order passed by my lord. Liberty was granted to the petitioner to surrender and move for 205 or 317. It was my lord, liberty has granted.
Same matter.
Same matter. Same matter.
Same order will pass. Not beyond any. Despite the fact that your client have concealed things.
No,
And
because
five
my
points to
application,
say
the first, my application, the first application.
Whatever.
Because my number is 27.
Whatever, see the
Yes,
contact.
yes.
Conduct is very
Some
bad.
question of suppression my lord, does not arise because
Everything has been suppressed. If this argument will be made, I have objection. Everything has been suppressed.
Take care, Babu.
No. This sort of section, then I will have
Don't try to
objection.
justify.
Yes, my lord.
There is beyond justification.
Yes, 205 application was rejected. Challenging that order, I have come. Well, this is very clear.
You simply tell me, are you justifying that you have rightly concealed these facts?
No, I have not considered any.
So why are you going into it?
Yes,
Pass the
yes,
same order.
exactly. I have
Don't go
not
into
considered.
it.
Yes.
But I have taken it very seriously. Therefore,
Yes.
5,000 rupees cost I have imposed last time. But looking into the health
Yes,
condition.
yes, that is the
Looking
entire,
into
my
the health
anxiety
condition
also that, my
on
anxiety also that.
Humanitarian ground,
Yes.
I gave some indulgence. So exactly the same thing I'll do, the same order.
And same order, and your lordship, the order has been passed long back. And the common sense of the client, my lord, is not to inform the senior counsel.
That's the difficulty. These
And
people.
he should have imposed heavy cost because of this attitude,
No.
knowingly.
5,000 is
This
heavy.
has not been, a reference have not been
5,000
given.
is heavy only.
The 205 application, I have challenging the order of rejection. For the question of reference, I have not filed an application for quashing the FIR,
If
not
you justify,
cognizant.
you don't deserve concession of 205 because of the conduct.
That
You can't keep on
yes,
changing.
that, but that
you
also
can't keep on changing
up to
law
my,
and,
no, that is
don't
up to
disclose
the,
things and
my lord, that is up to
trying
my
luck,
lord. I am not,
trying luck through different lawyers
yes.
by concealing the facts. That's the whole gamut.
Yeah.
So that is not permissible. So therefore, don't further aggravate it. Better that we take the same order. That's better.
This only question is because with a cancer patient, only my
That is
anxiety
the reason I'm giving.
Yes, yes, I have gone through. I have gone.
Otherwise,
I have gone through,
he should
lordship.
have been taken into custody by now.
Sir, I have gone through the order. My lord has passed this order.
I should have passed an order to take him into custody forthwith because of the conduct.
I have seen
But he is a cancer patient.
Yes.
Let us have a little human approach.
Exactly.
So therefore, help him out. Out of desperation, he might have done it. So give that benefit and try to do it. The same order will pass. Where is that order you have given?
Yes, yes, sir.
Okay.
I have also.
With a little modification, I'll do it.
Yes, yes, yes.
Okay. With a little, you show me so that I can pass. Okay. But please advise your client. Don't do that. Even if he has a good case, looking into his bad health condition, he would have got full benefit also, full relief from some court. If not I, some other court, because of the health condition. My conduct is creating problem for him.
For development, more application pending achi tor kon katla second application file kari dispose of kari.
It is a very
Yes, yes.
Exactly. That, only that your lordship has already considered. Only because of that.
So ye conduct kind
This is the cancer patient.
last stage of his life. Why he is doing all this?
ଆଉ ଯଦି ବି କଲେ ଆପଣ ତାଙ୍କୁ ବି ଇନଫର୍ମ କଲେନି ପୁଣି ଆଉ ସିନିୟର ଜଣେ କାଉନସିଲ କୁ ଇନଫର୍ମ କଲେନି then what is this conduct?
କଣ କରିବେ? Otherwise, he would not have accepted it.
Exactly.
Same thing he also said. I have what to do? What to do? Anyway, we will have a sympathetic,
Yes.
sympathetic approach. Will you have any reservation for cost? 5,000?
But my first application, there is no cost. This is my first application. The subsequent they have filed.
I will not impose
Yes,
cost.
that
I will not impose cost.
yes.
The case of FR laws in 341 and 323 and 307, 506 and 34, cognizance under same section. Well, now we compromise matter that the opposite party is here, but now in our court, so that matter will next week both have agree and file a
307.
307 matter.
So,
Injury simple matter. Also my
where is injury report?
the fair matter, but your lordship, the injury report is here matter.
So,
Certificate copy of the injury report.
so,
And that's same village, same locality.
hard, blunt object. Simple.
So that matter will next week. I file a affidavit in the oath commissioner or notary. A copy of my
I'll take it on record next week.
Next week, let them to appear. So,
Land counsel for the petitioner is placing on record. Hands up for the certificate copy of for the injury report, which is taken on record. Land counsel for petitioner submits that to the party has announced that is the dispute. The party would be appearing in the court on next date appearing, that is on 21st.
21st.
Bring them and we will do. online, whatever. huh?
Yeah.
Item 36, I am praying for quashment of order of cognizance. I will take your 5 minutes of your lordship's precious time, my lord.
Why 5 minutes? You take as much as you.
I am obliged, my lord.
But you should have a merit on the case.
Yes, my lord. Yes, my lord. I will not be wasting your lordship's time, my lord.
No, not wasting it. It's process. What is
My lord, your lordship may kindly straightway come to page 31 of my petition. This is the entire order sheet and why I am praying for quashment, my lord.
Yes,
Your lordship got it, my lord. Page 31 annexure 5. This is the order sheet,
31, yes.
my lord. Your lordship may kindly come to first date.
Hmm.
A complaint petition was filed under section 452, 384, 506, 420 and 34 IPC.
Right.
427 and 5. And this was filed before, your lordship may kindly come to, it is a filed before SDJM Puri. Your lordship may kindly take note of this fact. It was filed before SDJM Puri.
Okay, Puri, yes.
Thereafter, my lord, no steps next 2 days. And thereafter, FIR was instituted. One date is not missing in here, my lord, wherein direction was issued under 156(3) for registration of FIR.
Hmm.
That order is not here, my lord. The next date, my lord, 29/12/2020. Here, my lord, FIR was registered.
Yes.
Again, your lordship may see.
Seen the FIR, Sadar PS.
My lord.
So.
My lord. Your lordship may kindly take note of the fact that it is SDJM Puri. Again, next date, my lord. A case is FIR falls under section so and so, IPC is received from the IO.
Hmm.
Final form was submitted in respect of these petitioners. Issue notice to the complainant for filing complaint petition.
Oh, protest petition, okay.
Put up on it for filing. This is SDJM Puri again.
Hmm.
The next date, my lord. Order dated 7/7/2022. The case record is put up today. On perusal of the case record, it is found that the case comes under jurisdiction of NGN Puri. That means, my lord, entire order sheet till date is without jurisdiction. I'm again several mistakes are there, several irregularities are there. Jurisdiction of NGN Puri. Hence, transfer the case. Again, my lord, whether he has power to transfer, that will come, I will come to that. Whether he has a power to transfer, because it is vested with Hon'Ble Apex Court, this Hon'Ble Court and learned session judge. No other court has the power to transfer.
Interstate district decision.
Exactly, my lord. Whether he has the power to transfer. Before, my lord, passing this order, he had taken judicial note of the, my lord, filing of charge sheet and already issued summon to the complainant. These both are judicial acts. And a court having no jurisdiction could not have passed such order. Anyway, my lord. Again, my lord, if at all this is correct, if at all, assuming, my lord. The next court, my lord, NGN Puri took cognizance on a complaint. Complaint is file have is hajira, complaint is abstained, my lord. Order dated 4/23, my lord. Page 35. The last but one order.
Okay.
Here only, my lord, cognizance was taken by NGN Puri. If, my lord, foundation fails, superstructure will fail. Now, my lord, let us, my lord, come step by step, my lord. Whether he has a power, whether the police has a power to file charge sheet in that court, my lord. Your lordship may kindly take section 173, my lord.
Yes, 173 reads. Police has jurisdiction.
Again, the filing of charge sheet, my lord.
Yes.
Your lordship got it?
Yes.
Section 173, subsection 2.
As soon as
it is completed, the officer in charge of the police station shall forward to a magistrate empowered to take cognizance. So the court, having power to take cognizance, only can accept the charge sheet. And subsequent action is also, my lord, within jurisdiction.
cognizance is taken by the right court.
Cognizance is taken by right court.
Right.
But, my lord, the procedure adopted to transfer the files to the court concerned is, my lord, legal or illegal. That is to be verified by your lordship. Now, my lord, your lordship may kindly come to the complaint petition. If at all, let us assume, my lord, entire procedure is legal.
Now come to
Complaint petition, my lord. But to satisfy your lordship, my lord, Your Lordship may kindly come to,
Procedural irregularity,
I am also leaving that,
which is not prejudicial to you,
Milord.
will not vitiate.
Milord.
the entire-
Now your Lordship may kindly, your Lordship has gone,
See,
cognizance was taken.
if the wrong court would have taken cognizance, then the procedural irregularity might have prejudiced.
Milord.
Yes, yes.
But now, since the right court has taken cognizance,
Milord.
how these files have traveled from wrong court to right court is a procedural irregularity can be neglected at this stage.
Your Lordship may kindly come to
Cognizance stage.
section 190, Milord.
190.
Milord.
Yes.
Subject to the provisions of this chapter, any magistrate of first class and any magistrate of the second class is especially empowered in this behalf under subsection 2 may take cognizance of any offense upon receiving a complaint of facts which constitute such offense. Milord, first, upon a police report, here is not a case. Upon the information received from any person other than a police officer or upon his own knowledge. Now, Milord, here complaint is applicable to my case. Clause A, Milord. What is a complaint, Milord? Your Lordship may kindly come to that. Then I will, Milord, your Lordship may kindly come to section 2D. What is a complaint?
Are you conveying a point that
Yes,
protest
Milord.
petition is not a complaint?
No, I am not on that. Allegations made therein do not prima facie make out a case because it is not at all a complaint
Why are
petition.
you taking me to definition?
Milord, your Lordship may kindly come to complaint petition itself.
Means
The entire complaint.
allegation made orally or in writing to a magistrate with a view to take action under this code that some person, whether known or unknown,
I mean to say, Milord,
committed an offense, but does not include the police report.
Milord,
Yes.
my intention is to, Milord, draw your Lordship's attention. The entire narration made in the complaint petition is not about any act of commission of offense. He says that I have filed a petition, police has not investigated properly, police should have done this, police should have done that, police should have. So, on this petition, no court should have taken cognizance. This is my first point here. Your Lordship may kindly come to the complaint petition. Nowhere it is
Let us
stated.
see the complaint. Annexure 3.
Milord, page 24. Your Lordship got it? 24.
Yes.
The complainant is being totally aggrieved with the said unwarranted action of the IO and his final report number such and such, which was submitted in that PS case number so and so, arises out of 1cc number so and so, from the file of this Hon'Ble Court of Nyadhikari Grama Nyaya Puri, has filed this protest by leading few points amongst others. Like as such, when the same come to knowledge of this complainant last on such and such date, that the above said complainant was being the informant, he has filed a written complaint before the IIC of the Sadar police station on such, and again the so-called accused persons Ashok Das, both are sons of so and so, committed of their act of her offense under section 452, 384, 506, 420 and 34 IPC. This is the allegation they made.
It is stipulated time bound.
Again, the said accused persons were taken by IIC Sadar police station Puri. Furthermore, the concerned police officer didn't show any of his good intention or respond in any words of the present complaint, so that he was bound by these situations to shelter before the court of law. The Hon'Ble Court dated on 8th after receiving the complaint petition in order to make inquiry to the matter very prior and very prior to taking any cognizance in this regard, have been very much pleased to send this to IIC Puri Sadar station on the said complaint petition forwarded him on such and such date through the desk from the court. All these are narrated in this way. As a matter of fact, as per direction given in Hon'Ble Court SGM Puri, a basing number so and so, Prafulakar as an investigating officer took up the investigation of this accordingly. The said, your Lordship may see every para. It is also revealed from the records that the said investigating officer started investigation to the matter forthwith by opening case diary in recording such and such date. Next para 6, the said IO never investigated the case matter properly and more independently, keeping to all aspects. Although these complainants witnessed have been examined by IO, they have never stated so before him. For that, the entire statement made thereto and all self-made creation and such development, so also unbelievable expression placed in that 161 statements. For that, the complainant himself along with witness are not agreed. Another point to submit here that the concerned IO, in his opinion, while concluding the investigation, gave finding of that due to prior rivalry of false.
What are the evidence recorded?
Evidence, my lord, said that in evidence, my lord, They have stated. But I'm coming to that, my lord. Evidence, my lord, that is to be taken under section 200 and 202. Now, your lordship may kindly come to section 200. Evidence is required when it is a validly lodged complaint petition and the complaint petition must disclose, my lord, any kind of offense committed.
That's not.
I cannot, my lord.
That's not the protest petition idea.
Protest
Idea
petition is,
I'll tell you idea of protest petition.
my lord. Bhagwan Singh versus 85 Supreme Court, this started because of that to give a opportunity to the informant.
A offense is committed.
My lord.
See, the idea of the protest petition, I must tell you.
My lord.
A FIR is lodged.
My lord.
There are two types of collecting evidence.
My lord.
The evidence collected through the police. And once FIR is registered, investigation takes place. Police is given responsibility to collect the evidence, place it before court by way of charge sheet.
My lord.
Offense is there. Or it's a collection of evidence. But the police doesn't collect the appropriate evidence, file a closure report. Offense is not washed away. Then the protest petition, he says that see, the police should have done this and collected the evidence. He didn't do. So therefore, give an opportunity, I will produce the evidence. That I will produce evidence is 200.
My lord.
And he produced the evidence on the basis of which.
But protest petition also, my lord, protest petition also must, my lord, disclose commission of an act which is liable to be trial.
Protest petition, two-line protest petition we will also do, saying that the police has not investigated, give me opportunity, I lead the evidence. This is enough for a protest petition. That's the requirement.
Yes.
In the protest petition, you need not elaborate anything.
My lord,
it's not per se a complaint, as you are
yes, my lord.
referring to the
yes, my lord. My lord.
190. It is not a 190 complaint per se. It is a protest petition, means you are protesting about what?
About the investigation done.
Non-collection of evidence by the police.
My lord.
And you say that the police could not. That is the terminology used is protest. Protest against what?
Protest against, my lord, the action of the investigating officer.
Yes. He, in a very elaborately in the complaint, he writes, the protest petition he writes, police should have done this, that, blah, blah, blah. Police has not done anything. So therefore, give me an opportunity, and 202 evidences are laid. In evidence, everything has come against you.
My lord, it is about, my lord, conducting an inquiry under section 202. What your lordship is referring to.
Let's see the evidences.
My lord.
One after page 30 onwards.
My lord, in evidence he has stated.
Page 20 onwards.
Page 29.
29
and 30.
31, 30.
30.
There are two evidences.
Two evidences that was taken into record.
He has very specifically said that.
My lord.
So it has to be tested. It has to be tested.
My predicament is.
He might have been. He may be wrong, but it has to be tested.
Yes, my lord. That is to be. I am not on that. Whether reaching here is correct, to reaching to this stage, my lord, for collecting evidence through 202, whether it is correct a procedure, my lord, because the initial phase, the original complaint.
Come to 29, let us see. Come to the material.
The incident occurred on such and such date, your lordship got it at page 29. At about 4:30 p.m. at the house of the complainant, Kartika Samantray, and on that relevant date and time, Ashok Das and Maheshwar Das, armed with Katuri and Gotali, entered into the house of the complainant and demanded rupees 3 lakhs from the complainant as Dadavati and threatened to kill him. In life. And I intervened in the matter on that day. At about 2 a.m. and 2:30 a.m. By hearing some halla, we came to the spot of the occurrence and found that the above said accused persons damaged the boundary wall of the complainant. On the very next morning, I informed it about the complainant. In fact, my lord, before police, they have not stated in this way.
That is, they, once it's a statement, you know how they.
My lord.
Next evidence.
I know the complainant as well as the accused person of this case. The incident occurred on 6/9/2020 at about 4:30 p.m. in front of the house of the complainant. On that relevant day and time, I was standing outside of the house and saw the accused person, namely Ashok Das and Maheshwar Das, came with a Gotali and Bill Haq respectively and entered into the house of Kartikeshwar Samantray and demanded such and such.
Their allegations are there.
Allegations are there, my lord. But the procedure and the, my lord, transit part of the case record, whether this could have been transferred to this court in this way or not. And the first, my lord, the entire order sheet of the first phase, my lord, it was without jurisdiction. My contention, my lord. I understand what your lordship is opining, my lord, even if that was a wrong procedure adopted, but cognizance was taken by the competent court. But my lord, this is a later stage. My grievance is, my lord, this is a later stage. The entire, he has no power.
Merely it should have been transferred by the district court. District judge is again a procedural thing. It is not one
lord-
district to another district. High Court has a jurisdiction.
No, it's a procedure laid down, which na. Your lordship may kindly come to 201. Procedure is specific. Your lordship may kindly come to 201, my lord. What? 201. Had there been no procedure, then the entire thing is correct.
Yes.
Procedure by magistrate not competent to take cognizance of the case. If the complaint is made to a magistrate who is not competent to take cognizance of the offense, he shall. If the complaint is in writing, here it is in writing, return it for presentation to the proper court with an endorsement to that effect. The very word shall is there, my lord. There is no other alternative.
He has written it, but it is
ठीक है
he has written it to carry out to produce.
पढ़ेला तो right court cognizance नला
It is not the way. You cannot just throw the petition. This cannot the way. There is
Yeah,
a procedure laid down, my lord, which says the plaint is to be returned to the petitioner. It is alike to Order 7 Rule 10, my lord. Similar. There is no other alternative available to the my lord court. If your lordship will permit me, my lord, I will file a detailed note with all the required citations, my lord.
What citation is there? You have a propounded a very big proposition of law, but without any merits.
No, my lord, I am just convincing your lordship taking into the criminal procedure court because this is settled law. So I
want time, you can take it, no problem. But I'm not.
The wind is blowing against me.
I'm not with you.
The wind is blowing against me.
Because see, cognizance is taken by the right court.
I am not on that.
Only you can find fault with the only one order. That order is this is
Transfer
7/7/2022, where it says that I don't have jurisdiction. Let it go to the right court. It has taken. It should have been done by the district judge. It is a procedural error of transfer.
My lord,
He has
if this order goes,
power of a district judge to that extent, you can say.
just my lord, in a lighter
But
vein.
he has sent it to the right court, and right court has taken cognizance against it.
No, I have understood your lordship's view. But in a lighter view,
If
my
it
lord,
would have been otherwise, then you would have a case.
my lord.
सेटा चेंज ହେଇଥିଲା ତ ଯାଇଥିଲା ସେଟା ଚେंज ହେଇଥିଲା only that court is
Then,
not
but
matter would have been
Statement would have सब change ହେଇଯାଇଛି.
Since the cognizance nahi hai, then you would have a case. And he realized it and sent it to right court.
Certified.
Two persons.
So ସବୁ ଅଛି. I will file with affidavit. Your lordship may call it on Tuesday.
Not Tuesday, you give a convenient.
Sorry ଯିବା
First week.
complainant ର evidence ଟା ଦେବେ ଆଉ
ହଁ ମୁଁ ଦେଇଦେବି.
First week.
ପୁରା my lord, totally contradicting his.
Give me some time so that I can forget today's hearing.
আচ্ছা. Obliged me.
Otherwise, next week again I'll have the same kind of.
I am sorry that I have wasted your lordship's
No, it's
time.
not wasting. This is the exercise. That is how see, you maybe have a good point. We are referring to procedure of law.
Oh, yeah.
No problem. This is good. You have conveyed a good point, but the only thing is
There is no force with my submission.
52 million 52 ରେ compromise matter ଥିଲା personal appearance ଥିଲା ବାଲେଶ୍ୱର ଆସିଛନ୍ତି
52 ରେ ଆପଣ କୁଆଡେ ପଳେଇଥିଲେ ତାହେଲେ
ମୁଁ ଥିଲି
52 ରେ personal
ଗାନ୍ଧୀ ଯାଇଥିଲା
52 my lord
Sir is under
Page my lord, starting from page 21.
this, my lord.
20
Annexure 4.
Annexure 4, my lord.
This is 46, na?
No, that's 46.
46.
Item 46, no? Annexure 4. Annexure 4 is some written report.
Certified copy of the FIR.
Which page? FIR.
21.
First work.
21 to 26.
The copy given to me, page 21, annexure 4.
Who has filed the
FIR lodged by Pitambar Das.
Pitambar Das.
Petitioner, Informant Bipin Kumar Das.
Is the informant and present here?
Yes.
They're related to
Two
They are
brothers. Two brothers.
cousin.
Cousin brothers, my lord.
Petitioner, at the instance of the opposite party number 2, FIR number so and so under section so and so came to be registered against the petitioner. The petitioner and opposite party number 2 are the cousin brothers. On the intervention of the family members, elders in the family, the parties have now settled their dispute. They have filed affidavit.
My
They
lord.
have filed a very
My lord, joint affidavit. My lord.
Opposite party number 2 has filed the affidavit. Where is the opposite party number of affidavit?
Joint affidavit, my lord.
Joint.
Joint affidavit.
Now, a joint affidavit has been filed. What kind of affidavit? I have never seen in my life this kind of affidavit.
Yes, number Dana.
This is the High Court standard of affidavit. What are you writing? Nothing.
Yes, number
Except the name of the party, there is nothing in this affidavit. You at least you write which FIR. I suppose this is misplaced. And how this file will be placed in the thing, which FIR, what? Nothing is there.
My lord, Tiptal PS case number 156.
You may say you keep it in with you. But in this affidavit, what have you written?
No.
He is my cousin brother, I want to settle. First, finish. Joint affidavit. Now, I think we should have a little better practice. Letter file. I'll exempt the appearance. You file a better affidavit, I'll take it up tomorrow.
Yes.
They have
See the affidavit. What is written? Petitioner namely Pitambar Das and informant are now amicably compromised. And so, it's a good FIR, good affidavit, location, joint affidavit. What is the names? Who has initiated this? What is the FIR number? Which case you want to settle? Something you have to say. Otherwise, what? This is the wrong practice of the. I will just exempt them. They need not come. You file a better affidavit. So that today only you go and file a better affidavit. And what is better affidavit best left to you. You think over what is better, best.
GR case number and Tiptal PS case number mentioned.
No, joint affidavit. The parties have appeared. Yes, joint affidavit has been filed today. Joint affidavit dated so has been filed today, which is bereft of any particulars. Therefore, the land counsel for the petitioner seeks time to file a better affidavit during the course of the day. Let the matter come up for the further reading on tomorrow. Tomorrow. The personal appearance of petitioner number 1 and petitioner number 1 and opposite party number 2 are dispensed. Meet the matter tomorrow. You file.
41.
Yes. 41. The petitioner has challenged the order of the 11th Session Judge, Second Additional Session Judge Cuttack, in Criminal Division 43 in which the current Session Judge has defected the prayer of the petitioner for releasing a vehicle. But the Lawrence Trial Court.
What is the offense? Your 457 application was rejected by the first court.
No, first court has allowed.
JMFC.
JMFC allowed.
And they went in revision and revision reversed it. Okay.
Will kindly see the page 15, Miller.
Yes, read it. I am there. I'm already there.
In this instant case, the forester SAFA section has seized the one bearing
pick up bearing registration number such and such, and in the meantime, more of the 5 months have been elapsed. It is also seen that the competent authority fails to discharge the duty to assign him under the statute, and such failure is not attributed to the party.
What was the offense?
Offense is
Forest Act.
Forest Act. Only 20 logs, forest items. were seized
Whatever.
from the
Your Lordship, may kindly see.
Adjudication proceeding started.
Yes, that is why, Your Lordship, may kindly turn to page 25. 25, page 25. That is the revisional order, which has.
Then there is a bar operating.
Yes, yes, para 7.3. As it appears by the letter dated so and so, Assistant Conservator of Forest cum authorized officer of Kotak Division confiscating proceeding in respect to the seized vehicle bearing register number has already been started from 11/12 to the by Lord, page 25.
4/11/22. By the time the magistrate passed the order, that time it was already initiated.
Yeah, already initiated.
No,
That is the
bar.
whole difficulty.
It is the-
Forest Act.
56.3. Forest.
56.3, no?
My lord. 56.
50, no. 52C.
Yes, that is the trial court has dealt with. Will not kindly see next.
Trial court
next slide.
has wrongly dealt with.
Will not by
52C, na? 52, no, then 56.3. You are correct.
Mine.
56.3.
The property seized under this section shall remain kept posted of the forest officer.
You are central. That's what I was wondering. What is happening? 50.
Provided that the seized property shall not be released in the penance of the during penance of the confiscation proceeding or trial, even on the application of the owner of the property of such.
You are reading 56?
56.3.
56.
Plus got it?
56. Yes. Yes, 56.3, na?
3. The property, you also started in the word, the property seized under this section shall be kept in the custody.
A lot of state amendments, huh?
Again,
lot of
नहीं बाहर कर दीजिए मुझे सेटा खाली पढ़े you also may kindly see the book size mark
which one
56.3 you also may kindly see the flag mark
56.3
this side yes
okay
yes
3 property seized under this section shall be kept in the custody for forest within a third party until the compensation. This one no
then provided then
no court shall worry that.
No, provided you also
provided that seized property shall not be released during the pendency of the confiscation or trial, even on the application of the owner of the road. That is it.
That is
that was dealt by the current trial court.
Wrongly dealt.
No. Basing on the judgment by this honorable court. Basing on I am holding the judgment.
Yesterday only I passed an order. What had happened there is there was no confiscation proceeding initiated when the magistrate passed the order.
Yes.
When it came to revisional court, that time the confiscation proceeding was already initiated.
Yes.
Therefore, I said the revisional court was testing the legality of the first order. And the first order was correct. Therefore, I will not interfere.
Yes.
That's what I said.
No.
But here, when the first order was passed by the magistrate, by that time the confiscation proceeding was there in the case.
Yes.
So therefore, you can't.
Here,
yes,
before the issue notice, kindly see. Here, authorized officer issued notice. Here, you can in this case, kindly see the order.
No, issue notice.
Yes.
Here.
Issue notice and that was it is not bar to release the vehicle. It is categorically mentioned by this honorable
Which
court.
paragraph? Which one? Which paragraph?
I am submitting.
Which paragraph you are
Para 10 million.
yet to decide which paragraph you will read?
Para 10 million.
Yes.
Para 10 kind.
Yes.
Para 10 of the order.
Read it.
A notice is middle. A notice is said to have been issued on right substance of fixing the case of the five.
Don't read selectively one word. What is the purport of this judgment? You tell me.
Purport
You can't read one line somewhere and say that yes, you are covered by this judgment. You tell me what is the purport of this judgment. What is the ratio?
Purport of the case is that while the confiscation proceeding is pending, the authority can release the vehicle. Under para 10, 11
Yes.
of the from 10 to 11, 10, 11, 12.
Base.
नहीं, एक ही नहीं मो order judgment.
You read the sentence also. A notice is issued to have been notice have been issued
Yes.
by so fixing a date 5/10/2021.
Yes.
But there is nothing to show whether such notice is actually served upon the. So there is a dispute whether the confiscation proceeding has initiated or not.
Yes.
Here there is no dispute.
Thereafter can simply I am humbly sorry.
Assuming that the notice was served.
Yes, Lord.
There is no reason why the proceeding has
Kind.
kept pending.
Yes, sir.
Notice was issued on August, October. And the authority official. What is the stage of confiscation proceeding?
I don't know, but
in this case,
but whatever the documents have been next.
It is
From that
concluded
I-
or still pending?
I don't know, but I don't have any instruction because it is forthcoming from the order sheet of the learned divisional court. It is started since 4/11.
The petitioner is agreed by an order dated. What is that order dated? Order dated 4/10/2023, by which the revisional court has upset the order passed by the JMFC 1 Cuttack dated 20th April 2023, whereby the application of the petitioner under 457 CRPC was allowed. The revisional court next program. The revisional court has reversed the order of JMFC on the ground that the confiscation proceeding, by the time the order the JMFC allowed the application of the petitioner under 457 CRPC on
20th April
2023, the confiscation proceeding was already initiated.
Started from
on
4/11/2022.
4/11/2022. Therefore, the bar under section 56 section 3
yes.
operates. Then counsel for the petitioner has relied upon a judgment of this court dated 12/8/2022 in criminal MC number 174 of 2022. Inter alia, stating that despite the fact that the proceeding, in that case, despite the fact that the confiscation proceeding was pending, the coordinate bench formed the opinion that the application under section 457 CRPC is maintainable. Mr. Maharaja accept notice, issue notice to the state. Mr. Maharaja accepts notice, and he wants to examine the issue and revert.
I'll correct. May I permitted?
Carry out. There are some typographical error. The land council petition submits that there are some typographical error cropped into the record in the cause title of the case. He seeks leave of the court to correct the same. It is allowed. Let the petitioner carry out the correction in the court and countersign. Yes, next.
42.
May it please, ma'am. There's a civil dispute given a criminal color. Matter has been settled. Page 129, if your lordship sees. Page 129 of the brief, annexure 7 series.
Yes.
Your lordship may kindly permit me to read the para 2 of the
But
page.
there is 307 also.
No, my lord, 294, 354, 506, 436.
307 is not civil dispute.
No, my lord,
Fact.
the FIR doesn't disclose so, but the matter has been settled and affidavit has been filed before this honorable court. That is
That's
a
right. But what is the injury report?
as such there is no injury because the allegation is that the petitioners tried to burn the house. That is the allegation in the FIR. And if your lordships only sees page 129 for a moment.
120?
129.
Yes, that is what
Yes.
affidavit filed by.
Affidavit filed by the informant in another anticipatory bill, para 2, if your lordship sees. After registration of the aforesaid case, the matter has been settled among us out of court, and as it is arises out of a previous long-standing civil disputes, keeping in mind the future relationship, I am not interested to proceed further with the present case against the petitioner and other accused. I have no objection if the petitioner will be
That is in bail.
Yes, that
Thereafter you got bail.
subsequently, this affidavit, basing on this affidavit, the bail application has been disposed of, remitting the matter to the learned magistrate to consider the application in light of the affidavit filed herein.
Yes. Where?
42.
Where are they? Where are they?
No, but this is coming for the first time, if your lordship.
Call them.
When
will you call?
Compromise?
Huh?
Compromise?
Settlement.
Affidavit.
But why is the anticipatory bill has been rejected and they have been
No,
directed to
thereafter
surrender?
what it is rejected. Thereafter what had happened is they filed a affidavit saying that we have settled the dispute, and on that basis bail was granted and remitted back to the trial court to consider the effect of the settlement.
Right.
And there are many offences which can't be
Yes.
compounded, so therefore he is filing.
Yes. Let them do.
When?
Your lordship may kindly issue notice in one of the one informant is one only.
Not supporting now.
No, my lord, that instruction, but if your lordship's issues notice, then it will be easy.
Issue notice to the Learned Counsel for the petitioner, Mr. Marana, Learned Counsel for the petitioner submits that the parties have settled the dispute, and an affidavit to that effect was also been filed by the informant before the coordinate bench of this court in APL number 12324 of 2023. On the basis of which his clients have got the regular bill. Got the regular bill.
No, my lord, it has only been remitted, taking to consider the bail application in view of the settlement. That is at page 1.
Still in jail.
No, I'm not in.
You got the bail.
Pursuant to that. If your lord, I do not have that instruction. But
say
133 page re, your lordships, this honorable court directed the learned trial court to consider the bail application in view of the settlement filed herein. That is at 133 up next.
Page kete?
On the basis the coordinate bench of this court by order dated 2/11/2023 in the said bail application has relegated the parties to the court below to place on record the settlement and seek appropriate remedy. Seek appropriate remedy. And the said orders are placed on record. Issue notice to the opposite parties.
Opposite party number 2, madam.
Opposite party number 2, Mr. Marana accept notice on behalf of both people. And so, in the interim measure, the proceedings is postponed.
Madam. Obliged.
Stay till next date.
Obliged.
Yes.
May it please, your lordship. My lord, the petitioners pray for passing of the complaint case that has been initiated against them, including the order of public.
Pass on that. Yes. Yes.
My lord, the petitioners pray before your lordship for passing of complaint case, including the order of cognizance. Such type of complaint your lordship may consider it is not maintainable.
And the learned magistrate has taken cognizance even which is not possible under section 447, 307.
Why?
Yes, Your Lordship. I'm first placing the cognizance order. Page 45.
Hmm.
Page 45, order dated 23/11/2023.
Yeah.
My lord.
Hmm.
The case record is put up today for hearing of the cognizance. Had the learned advocate for the complainant peruse the complaint petition along with the initial statement of the complainant and statement of witnesses examined by the court during course of inquiry under 202 CRPC. The complainant, apart from her evidence, has relied on statement of two witnesses. To occurrence on the scrutiny of their statement, it is found that they have not only supported the facts stated in the complaint petition but also have corroborated to the statement of the complainant. I find prima facie material for offence under section 447/307 of IPC alleged against the accused persons. On perusal of the evidence, it is found that there is sufficient ground to proceed against accused persons, namely Alok Ranjan Pradhan and Santoshini Pradhan under section 447/307 of IPC. Hence, cognizance of the offence under 447/300 IPC is taken. My lord. Your lordship may kindly see there is a civil dispute pending and the Honorable Court has passed an order in the second appeal on 18/4/2023. It has gone in my favor. On the same day, 18/4/2023, this complaint was made. Your lordship may annexure 2, I have annexed the civil court's order also.
Same day you go and attack, then what will happen?
That is
Same
the
day, out of what you call jubilation, whatever you call, you own the case and went and attacked.
my lord. We are parties, we belong to one family. Annexure 2, the order of the judgment of this Honorable Court in second appeal is there, wherein both are parties. Your lordship may kindly see the glaring illegality first I am submitting. Annexure 3.
How will you get over 307?
Yes, Your lordship, that is I am submitting. Annexure 3, the initial statement recorded of the complainant under section 200 and the two witnesses the learned magistrate has referred. Annexure 3, page 34. Page 34, 35, 36.
Yes.
One paragraph they have stated. My lord, the word of Santoshini Pradhan has not been uttered. If the learned magistrate is of the opinion that Alok Pradhan and my wife Santoshini Pradhan, we are accused persons and there is sufficient material, at least, Your lordship, my name should have been uttered. I am reading, Your lordship. Page 34.
I'm here there only.
On 8/4/2023, at about 7 AM in the orchard at Sujanpur, the occurrence took place. I was in the orchard doing my work and Alok Ranjan Pradhan came there and trespassed to orchard and forcibly took mangoes from the orchard. When I protested the same, he abused me and held me by neck and tried to press my neck. Then I fell down. Hemant Kumar Naik and Sushant Mangraj were present during occurrence. I lost the affair at PS on 9/4/2023 at 3 AM. The accused again came and orchard with an axe and chased me. Thereafter, I again lost the affair, but no use. Then on 11/4/2023, I informed the matter to SP Kalandi that my case was registered at
Come to 35.
My lord, page 35. I know the complainant and the accused person. On 8/4/2023 at 7:30 when in Sampas, my lord, Sampas Garden at Sujanpur, the occurrence took place. I and Sushant Mangraj went to buy mangoes from Sampad. Alok Ranjan Pradhan came running and pushed the complainant down on the ground and started pressing his neck. We went to separate them and the accused persons ran away, but the complainant became senseless and was unable to breathe. If we would not have separated, the complainant would have died.
Come 36 now.
My lord, page 36.
Para 2.
I know the complainant and accused. On 8/4/2007 near the Bagicha at Sujanpur of complainant, the occurrence took place. I and Hemant Kumar Naik went to the spot for buying mangoes. At about 7:30, I heard noise and ran to the spot and saw accused was sitting on the complainant. Different versions, Your lordship, and pressing neck. As soon as he saw me, he ran away.
Accused means it is a singular.
Complete, my lord, may kindly see 307 invites, life imprisonment, if hurt is caused. Now, very casual manner, Your lordship.
What is this? There is no one has taken the name of at least.
This is very.
Number 2, yes.
How can the cognizance be taken?
My lord, if Your lordship will permit, I'll read one paragraph of judgment, Your lordship. Honorable Supreme Court judgment. What has been stated?
Okay, sir, notice
What will you do? But now
The Honorable Supreme Court said in such casual manner it must not be done.
you could have you have already persuaded me. You want to damage the case by reading further. See, right now. But what about Alok?
My lord,
Alok.
no, annexed.
Only Santosini.
That is
Your
true.
Lordship, she is out.
Yes.
It has to be quashed.
My lord, by this way, your lordship, the learned magistrate will take cognizance of a sessions case, and your lordship may kindly say complaint petition wherein she is saying that is not my land and it is disputed under Annex 2. I have given 1/4 share on it. 447 is not invited, my lord.
Who are the parties to the RSA?
My lord, your lordship may kindly say Annex 2, page 14.
13, you come to 13.
Page 14, page 4, sorry, page 14, party number 4, Sampad Pradhan. He is the complainant.
Sampad Pradhan is a complaint against.
And 1B, Alok Ranjan Pradhan. I am the accused. And my wife, Santosini Pradhan. She is not a party in the second appeal.
There are many.
Many other persons are there.
What? This is a suit, huh?
This is RSA, your lordship.
No, arising out of suit.
Arising out of suit,
What
long
kind of
pending.
suit?
Long pending. Is it the partition suit, your lord? Suit for partition?
You are related or what?
But my lord, we are belong. He is my own uncle.
Why don't you settle?
My lord, Annex
I'll
2.
say it, they will automatically settle.
My lord,
Say the proceeding automatically will settle.
yes, your lordship.
That's the best way of doing it.
My lord.
You just tell me, he is your uncle.
He is my uncle.
Sampad is your uncle.
My lord.
At the instance of opposite party number 2, complaint 1cc case, 1cc case
102 by 2023.
1cc case number 102 of 2023 was filed against the petitioners. Petitioner number 1 is the husband of petitioner number 2. So, sir, the opposite party number 2 is the uncle of petitioner number 1. So, sir, there is a long-standing civil dispute pending inter se parties. Full stop. Eventually, on 18/4/2023, this court, by order dated, by judgment dated, which is judgment dated 18/4/2023, allowed the RSA number 474 of 2014 in favor of the petitioners. Petitioner. On the very next day, same day.
Same day.
On the same day, the opposite party number 2 instituted the complaint against the petitioner. While recording the statement under 202, all the witnesses have made minor allegations against the petitioner and no allegation against the petitioner number 2.
My lord.
Petitioner number 2. Despite that, the court below has taken cognizance of for the offence under section, what is that cognizance?
447 by 307.
447
7 by 307.
and
307.
You went, took mango from their orchard and
Started quarreling.
pushed them for 307.
My lord.
So, sir, the allegation against the petitioner number 1 in the complaint and in the statement under 202 CRPC is only that he has forcefully entered into the mango orchard of the opposite party number 2 and pushed the opposite party number 2.
My lord.
As a result of which the opposite party number 2 fell down. Therefore, cognizance on the basis of the state allegation, cognizance under section 447 oblique 307 has been taken against the petition. Issue notice to opposite party number 2, retainable within 4 weeks, 4 weeks. And in the meantime, the proceeding before so is stayed.
Obliged, your lord.
My lord, here is the unfortunate informant who is a rustic and illiterate lady who has lodged a complaint regarding the missing of her minor girl child. But the police, even if she has categorically stated about the name of the accused in the 161 statement, but police has not taken any steps in accordance with the law in regards to sexual offences regards to minor girl.
Girl is recovered or not?
A girl is recovered, but no medical examination took place.
No 164.
No 164 is there. But very interesting thing that they have not conducted the medical examination. Even if the mother's consent has not been taken. And further, that they have taken the 161 statement of the victim in the police station, not in the house of the victim. And also not in...
What does he say?
Right?
What does the victim call?
He says, which is not credible. I am reading that part. Annexure 5 is 161 statement of the victim, 59.
Now charge sheet is filed.
Charge sheet filed.
So what do you want then?
The further investigation of the case, because they have not added.
No certificate to that respect has been.
Yes, I have annexed.
No
I have
certificate
annexed that order.
Annexing a document
Yes,
is not.
I have annexed. I have given the also certificate. I have
Not a
given.
certificate.
I have given it.
Yeah.
That is CRLMP.
What was this?
That is CRLMP.
2131.
My lord.
Whatever this petition.
Now that is CRLMP filed by the petitioner before charge sheet for adding the offences and proper investigation.
You lordship may kindly see the order, what the order passed.
Yes.
Better application.
Better application.
Better application. Liberty I have taken.
And certificate you lordship may kindly see.
No, no. I have annexed that order.
Phase 2. Phase 2. Whether you have given the certificate you are saying.
58.
I have given.
58 kindly have a glance. 58. I have annexed that order. I have not suppressed.
Phase 2 of the petition.
Yeah.
State what's the petitioner versus state of Odisha just below.
The matter out of which this petition arises was
Never before this in the present form as per the instruction received.
In the present form, this is after charge sheet.
No.
I have annexed. I have.
Why are you doing all these things? Why can't you write properly spell out? I have earlier approached.
Yes, I have written.
Nothing. You have virtually concealed this fact.
No. I have written that. Yes. Para 11. Para 11 kindly have a class.
11.
Yes. That due to such inaction, illegal action on the part of the investigating authority, para 11, page 9. Authority in regards to improper investigation, not addition of relevant offences, the petitioner approached this honorable court in CRLMP number so and so with a pair for pursuing appropriate direction to the investigating authority.
Okay, so now come to charge sheet. What is the offence?
This is what you also may kindly turn very important things is page 60, annexure 6.
16.
Yes, no, page 60, 60. 164 statement of the victim. Your lordship may go through the statement, then your lordship pass any order as your lordship.
I am coming to it.
Yes,
I am coming to both 161 and 164. Let me read 161.
The earlier offence was
363. Even
charge
if
sheet is filed under 360.
no 363, 366.
What is wrong in it?
No, I am why saying I have given the name of the accused on the very date of registration of FIR. They have registered the FIR for unknown person against unknown person. Even if Dilip Patra name has been given, and thereafter they have rescued the girl after FIR registration after 15 days. They have not gone to the house of the Dilip Patra. And Dilip Patra arrested in 210.
We can't in the 482
No, my lord.
look into
what
manner they have done.
No. They have not followed the SOP. All the SOP, what they have to do, SOP that they have given issued by the crime branch itself says, ta house re taku karibo 161 statement and medical examination karibo consent of the mother. They have not done medical examination.
On that basis, can
medical examination co basis
366 what 366 says, kindly have a glance. 366
let us read 164.
Exactly. You also may kindly see the 164 statement.
The offence is made out or not, that has to be seen.
No. I am saying she is a child of 14 years. And she...
This is a application for passing of the inter proceeding.
The affair story which is,
Before you start anything, you started laughing means you don't have a case.
I have a case
You-
because I have heard from my brother
You
that
are,
I
you
think that
yourself is not convinced, still you have to do your job.
no, it convincing.
Let us see what you say.
Your Lordship, come to page 12 of my brief. The present infant admitted in nursing training school. She wanted to be admitted in Baripada. Instead of Baripada, his
You are asking question
passing, my lord.
of FIR.
Huh.
What
That,
stage of the investigation?
The investigation is going on for passing of affair because it's not a case that I have cheated or anything else. The present petitioner is the director of the nursing institution.
Yes.
After applying the same, she has been admitted at Noida. She wanted to admit me in Baripada instead of Noida. And thereafter, she wanted that to refund my money. And we have refunded the money. We are not.
You are the principal.
My lord, my lord. That is the allegation in the affair. And so also, the present petitioner, while taking the best effort, and it is better to refund the money because we are not cheated. That she has admitted that instead of Baripada, she has been got admitted at Noida. That is the case. And she has refunded the entire amount. The amount which
She
has.
is studying in Baripada or Nayagarh?
My lord?
Now she is studying.
Now she does not want to prosecute at Noida. She wanted that to refund my entire money, which I have given to the institution. That is the case, my lord.
You paid back.
My lord. That is, she has got that.
My lord, earlier, my lord, my friend filed another criminal miss case, CRMC 123/4/23.
That is a regular habit in this.
That is
File and
disposed,
conceal.
my lord, that is disposed of, my lord. I read out the my order. Considering submission made and having regard to the fact and the investigation in, and that the investigation into the case is in progress, this court does not deem it proper to interfere at
Yes.
this stage. However, consider the specific contention raised by the London Council for the petitioner as regards the role of the petitioner in the alleged occurrence. This CRMC is disposed of granting him liberty to approach the investigating officer appropriately within a period of 2 weeks.
I have approached, and with the presence of the person concerned, I have returned the amount. Your Lordship, state to come to pay. That is the order of this Honorable Court, my Lord Justice Shashi Mishra.
Interestingly, my friend filed the affidavit, my lord, of informant, which was annexed in the earlier case, my lord.
Here also he has filed.
The same.
Annex करनଥିଲି, annex करनଥିଲି, काहे देखियो?
Annex
नहीं, तो annex करिए, Monica साहब. What does she say?
Your Lordship.
से पूर्ण केस कर रहा
नहीं पूर्ण केस नुह
1 2 3 4 2023.
I so and so that I am the informant in the above mentioned case in connection with Baripada town PS.
It was there by the time. Order was passed.
Informant was interested in getting.
Which is now pending in the court of the London SGM. That the prosecution allegation in Nursil so and so that is she has narrated what she has narrated in the affair. Accordingly, she had paid the amount for admission in the nursing training. It is further case of the informant that in the respect of some amount cash receipt has not been given to her.
If you have informed the police, why don't you wait till the charge is filed? How can you come again every time? Wait, he will file whatever. How do you know that he will close the case?
Already you have filed the affidavit with the IO.
In FIR stage you came. Court said that okay, since you have paid, go and tell the. What is the idea of saying? Once you tell, they drop the case.
Exactly.
He has not dropped the case. He has not done it
Till today. Till today.
Then you are apprehending that.
For the securing the ends of justice.
ଆଜ୍ଞା
କେବେ କରିବେ କହୁନା
ଆର୍ଜନ
କଣ କିଛି ତ ନାହିଁ କଣ
ଇନଷ୍ଟ୍ରକ୍ସନ ନେଇଯିବ ଇନଷ୍ଟ୍ରକ୍ସନ ନେଇଯିବ
ଦିଅ ମୁଁ ଲେଖିଦେବି so that easy order କାଇଁ
Order
Shashi Mishra order.
My Lord Justice Shashi Mishra.
Why are you coming so quickly?
Because no, that has been disposed of in the month of 2010 12/3. Till today that case is pending.
2012?
9. 23 এটা কেসটা
23 to 24 January.
এটা কেস ହେଲା 2018 નો.
Where is that? Where have you read it? Give it. The copy of that.
30/3/2018 નો કેસ. Page 10 annexure 1.
Annexure
1.
Page 10.
10 my lord.
No. Give me that order of Justice Shashi Mishra. Where is that?
Order টা
order ଦେଇଦେଲି
Where is that? Give me,
Printed
why are you waiting?
ମୁଁ just now support.
Huh?
କପିଟା ପଠେଇଲି just ସେ ଯେ ପ୍ରିଣ୍ଟ ଆଉଟ୍ କରି
Right now. The
ଆଡମିଟ୍ କାର୍ଡ ସବୁ ଅଛି, ସବୁ ତକ ନେଇଥିଲା।
petitioner had earlier approached this court by filing CRLMC number 1234 of 2023, seeking the same relief. In that proceeding, the petitioner has relied upon an affidavit.
ନାଇଁ ଆଫିଡେଭିଟ୍ ଦେଇନି ସେଥିରେ।
affidavit file
One minute, ଆପଣ କେସ୍ ବିଷୟରେ ଜାଣିନାହାନ୍ତି?
ଲେଖା ହେଇଛି?
No more than.
କୋଉଠି?
ଏଠି affidavit ଦେଇଥିଲେ ସେଇ କେସରେ affidavit ଦେଇଥିଲେ
Your Lordship, I have got that brief.
One minute, let me write. I understood. In that proceeding, the petitioner relied upon an affidavit. No, in that proceeding, the informant had given an affidavit inter alia stating that she has received back the amount alleged to have been alleged to have been taken from her in the pretext of giving admission to her in the nursing class. Taking note of the said affidavit, the coordinate bench by order dated 28/3/2023 has passed the following order.
My lord, that case affidavit has not been filed.
This is what you have, page 15 you have annexed.
नहीं annex से नंबरटा पुराना नंबरटा पके दीजन सीतरा पे ऑर्डर टाइज से दिन से affidavit filing करनी my lord.
How do you know? Why should I not believe this?
That is the sole.
Then I shall I take it that you are trying to mislead me?
No.
Then why are you doing like that? Just see page 15. What have you done?
ଏଇଟା ଗୋଟେ ପ୍ଲେଟ୍ ଦେଇଛି।
କେସ୍ ନମ୍ବର ପଡିଛି କେସ୍ ନମ୍ବର ପଡିଛି
କେସ୍ ନମ୍ବରଟା ପଡିଛି।
Land counsel for the petitioner seeks to withdraw this petition being premature and to approach this court at appropriate stage. Dismiss is withdrawn with liberty as present. I read that. I thought that affidavit is given there. That's what your annexure is.
Yes, no.
And the annexure is then.
Case number
how can you?
ଆଗ କେସ୍ ନମ୍ବରଟା ପଡିଛି।
Then
we can't dispute that.
that is the whole.
They have annexed here.
That is the reason I got persuaded. What is this? You do wait. Yes, next.
Oblige.
It's always misleading of this. Huh? What is this? 53? Nobody appears.
53 and 54 same matter.
No, why for it is listed?
ऐसे देई नाती correct address रे
Entry modern आई तो there is no entry modern. By order dated 31/1/2024, notice was issued to the opposite party. However, no requisites are filed.
Late filing.
Huh?
Late filing.
Requisites filed person.
Late filing.
However, the requisites were filed belatedly. Therefore, no notice could be issued. The petitioner may take first step.
Accept पड़ेगा। You will also accept the late filing, then it will go.
Office is direct to accept the.
Office is direct. You will also direct office to accept.
Office to take
Accept the-
appropriate step for issuing notice by accepting the requisites filed. to the
Yes.
secretary.
Nobody is active.
Nobody is coming forward.
56.
56.
May I please?
Yes. Yes.
Your Lordship, my learned senior audio through VC.
Yes.
Lord, this is a petition under section under section 482 seeking to
Somebody was asking Mr. H.S. Mishra, my lord. In the first hour, he prayed for time as because he was the freshly appearing in this case, my lord. Earlier, another counsel was appearing, my lord. And the opposite party to change the advocate and his name not appear in the court title. So H.S. Mishra. For that, in the first hour, he approached for adjournment.
Yes, somebody mentioned Mr. Mishra, somebody mentioned
pointed to when the matter is
sometime.
My lord, the sword is hanging on my head, and I am a senior resident doctor in AIMS.
Earlier counsel.
Item 56, Mr. H.S. Mishra, my lord. He will appear in this, my lord.
Earlier, he was in this case.
You have given no objection.
Earlier, I was conducting that case.
You have given no objection in favor of Mr. Mishra.
Yes, my lord.
See, the earlier law has.
My lord, I'll just pray that the records are there. My learned friend, they've taken a no objection. So your lordship may fix it on Friday or maybe on Monday.
Monday, Tuesday, Monday,
Tuesday.
Tuesday.
Your lordship may not keep it on Tuesday, either on Monday or on Wednesday.
Wednesday, okay, Wednesday.
Very grateful, very grateful.
Your lordship, the interim order to continue.
Interim order to continue.
Hon'Ble.
When it was mentioned, somebody told Mr. Mishra, who mentioned, I asked him whether interim order is operating. He says that yes, it's operating against me. Then I said, okay, it's all right, no problem.
The operation,
minimum courtesy is required. You should tell the other side. See, otherwise, I will not entertain mentioning like this. Somebody comes and takes the date, and the other lawyer comes and says that I was not informed. What is this? You can't take the leniency of a court so lightly. Henceforth, for adjourning afternoon is better. Don't adjourn. Yes.
21st.
Yes. Lot of hearing taken place. Interim order. Yes.
In this case, there are 3 matters. So for a second matter is CRLMC 2565.
Yes. There are how many matters?
3 matters.
3 matters.
First, 2548 and 2565.
You are
challenging all the 3 cases. I am appearing for the opposite party. Challenging the order of cognizance. And the last matter 2838, that challenging rejection of 205 application.
Okay. Which one you want to refer? First one?
The first one, my lord, senior counsel appearing, Mr. So
The other application will take it up to 2548.
254 apple.
Oh, first one.
2.
Yes. Okay, 2548.
That matter there. Mr. Mahathir will have
No, it's 2565. My mistake. It's 256.
2565. Okay.
And you see the affair, page 17, Annex 1.
What do you want here?
Your the initiation of second proceeding, criminal proceeding for self-same incident between. Yes, for self-same incident for self-same parties. Second criminal proceeding is not maintainable.
Insofar as the first criminal proceeding is concerned, cognizance is taken.
Cognizance is
You
taken.
challenge that cognizance.
No, I have not. First case I have not challenged. Second case you have challenged.
All the 3 cases pertaining to the second one.
Second
First
one.
case is going.
First case we are not challenging the impugned order, challenging the cognizance. Here, this is a case where charge sheet has been submitted.
In this case.
In this case, but kindly see the cognizance order. I have annexed that cognizance of page 29.
Yes.
So starts from page 28. Though FIR was registered under section 302(120)(b), background of the case, little background I am giving. This is a case of accidental born. I am the wife, my husband has secondary injuries. Here, this is a case soon after registration of FIR. State government formed a investigating agency constituting 9 or 10 members.
SIT.
No, crime branch. Though initially it was investigated by the local police.
Okay,
Crime branch, yes, investigating team was constituted. Dying declaration was recorded. PM was conducted. After some investigation, investigating team has come to a conclusion this is a case of accidental born. Cognizance was taken. Someone was issued. I appeared, filed a 205 application. My application rejected. I came before this honorable court. That order was set aside and remitted back to the lower court. Thereafter, what happened?
This is the first case you are talking about.
Yes, I am not in first case. Subsequently, informant filed a petition. Kindly see Annexure 4 series page 30.
Okay.
Page 30 of my brief. My lord, got it?
Yes.
Kindly see the prayer.
47.
Page 47. I got it?
Yes.
Therefore, the complainant prays that your honor may graciously be pleased to consider the facts stated in the complaint petition and make kindly direct for further investigation.
173. Okay.
Yes, 1738.
Okay.
This is the prayer made by the informant himself. Learned magistrate, what he did, he complaint petition treated as a protest petition treated as a complaint petition. 202 inquiry was conducted. Cognizance was taken under section 302. Kindly see the order. Page 58.
Yes, really.
The case record put up today for accordance with necessary order in respect of cognizance, and counsel for the complainant present files Hajira had perused the complaint petition, statement of complainant recorded under section 200 of CRPC and evidence recorded under section 202 CRPC and other available material and record. On my perusal, I found that there is a prima facie case is well made out under section 302 120B of IPC. Hence, cognizance for the offence under section 302 120B of IPC is taken. There is sufficient materials to proceed against the accused person, such and such, such and such, such and such. The complainant is directed to file request put upon such and such.
Where is the second case?
Malad?
Why are you saying it's second case? It is not a second case. It is the same case. It is the same case. Earlier it was
Police case on protest petition.
Protest petition is taken. 200 evidences are taken. Now 302 cognizance is taken. Why are you saying that there are as if one case is going on and this is the second case? It's not that.
Yes, incident is one.
Incident one, case is also one.
Yes, incident is
You
one.
may be agreed by the fact that cognizance under 302 is taken against you. You
Yes.
may be agreed by that. You may say that there is no material, there is irregularity, whatever. But
Yes,
you can't say that
that,
there are two cases.
on merit I will come. I will come.
Address me on merit.
On merit I will come. Now, blood in technicality.
And the fact that you said that one case is going on. I thought trial is going on. So this
No. Cognizance was taken. I appeared at 205. It was
on merit you come. This
yes.
is one case. Yes.
Now the blood. This is the entire background.
Yes.
Now my first submission is that the order itself 12/4/2023 is prima facie is illegal. My lord knows 202 is a post cognizance inquiry. My lord knows that is the statute. 202 is a post cognizance inquiry. First magistrate will take cognizance. For issuing process, he will have to make an inquiry under section 202. You will kindly see the 202.
Argue all these things in the charge stage.
My lord?
Argue all these things in charge stage.
No, once my lord, initiations of proceeding is bad.
That it will not evaporate. These points are there. You can argue on charge stage. Why cognizance stage? I will get into all this.
No, my lord, on the basis of protest petition, My lord, no, the magistrate has no inherent jurisdiction. If a party has come a specific prayer for further investigation, can the magistrate exercise inherent power, can direct for registration of a complaint case?
Yes, that can. It is settled in the.
ଟିକେ ରୁହନ୍ତୁ ଆଜ୍ଞା, ଆପଣ turn ଆସିବ, ଟିକେ ବସନ୍ତୁ, ଟିକେ ବସନ୍ତୁ. You have patience. You have a patience. My respectful submissions would be, but there are two kinds of protest petition. One protest petition urged against report under section 169. That protest petition will be treated as a complaint petition. So far as 170 is concerned, if charge sheet has been submitted, if the party wants to file a protest petition only for further investigation, re-investigation or investigation by this particular agency.
You support your proposition by any judgment?
Well, I'll
show me your judgment. I understood it, what you want to say. Show me the judgments. Straight away, come to the judgment.
I'll give that.
Give me the judgment. I understood your proposition. I give that much credit that I understand what you say. Show me the judgment. Otherwise, you are wasting our time.
No, I'm not wasting time.
So give me the judgment.
Yes.
I understood your proposition.
Yeah, now this is one. I'll come, my lord, one by one.
If you want to further take this point further.
Yes, this is number one.
Yes.
I'm giving one by one. I have come with the judgment.
Next point.
Because my senior has not come. This is number one.
Then senior
has already come.
I requested my friend to continue the argument. Later on, I will join. And I am
come. Let us hear him because because since senior has come, let us hear him.
No, it's all right. You can start. No, I have no issue. Yes.
May I please your lordship? So far the Code of Criminal Procedure is concerned, it is a complete code. So far the administration of criminal justice is concerned. Various provisions have been inserted in the code to meet all the contingency. Keeping in mind fair trial one aspect. Second is the interest of the complainant or the victim. Third is the interest of the accused. So it is, that's why I addressed your lordship that it is a complete code. What are the provisions in this situation? Let us take the case in hand. Just legally I will bring my lord's kind attention. Here is a case. Charge sheet was submitted, but not on section 302. Not these fellows, those who are before my lord, they are as accused for commission. Thereafter, the protest petition was filed. Whenever a protest petition is to file, yes, every person, if aggrieved, is at liberty to file the protest petition, though law has not specifically said so. On receipt of the protest petition, in case where charge sheet has been submitted, or I can say final form has been submitted, in that case, first and foremost duty of the court is to peruse what are the material collected therein. If he is satisfied that the police with an deliberate intention, though there is material, exonerated some persons or lesser the offense, he can so much proceed. That power is vested with the cognizance court. If he is not satisfied that the material...
Give an opportunity to bring further evidence through...
Yes.
Yes.
Thereafter, you will call upon the party to produce further evidence to proceed further.
The idea is to collect evidence. If you collect evidence which has been already collected, on that basis, cognizance is rightly taken or not. If it is not rightly taken, give further opportunity so that...
Exactly. Your lordship is right on that point. Now, I am inviting one thing. The lordship have a glance to the complaint petition, protest petition, which has been filed.
Yes.
Page 18.
Page?
18. 18. Annexure 3.
Yes, 3. 3 starts from 27.
No, no, the brief is different. I am placing my submission
In CRMC number 2548 of 2023.
2548. Okay. Mr. Pradhan, one minute. 2018, huh?
Yes, sir, Lordship.
Okay. 18, okay. Pause.
three things I will point out from that.
Hmm.
Your Lordship may have gone through the caption that was written after the 1cc case number so and so, in the bracket, protest petition arising out of Paralakamudi PS case number so and so, corresponding to GR case number so and so. So reference was given showing that there is a police investigation and ultimate it was ended in submitting final form. Your Lordship may come to column number 8, document relied on.
Final form.
Final form submitted by the IO in GR case number so and so pending in the court of the SGM Parathon. That means prosecution itself relied those piece of materials as their document. It is not I. That's why while submitting my submission, your Lordship is to give what are the materials collected because they are relying.
But there may be a situation that there are evidences, but they still police final form.
Yes, yes.
So therefore, the magistrate has to see what are the evidence, not the narration in the FIR. Charge sheet.
No, I am not that point. First of all, they relied that document. What I submitted that on the basis of receipt of protest petition, court is supposed to go through what are the materials collected.
Already collected.
Already collected. And that was relied by the prosecution. That is my submission. 8, column number 8, as per our GRSU, that relates what are the documents you want to rely, and they relied on that.
Right.
Am I clear, my lord? Now, from that, I will start my argument so far the factual aspect is concerned. Now, your Lordship may turn to page 22 of the said annexure. 22, no? 21.
21. Yes. Chronological date.
That is a chronological date of event that was mentioned. In this case, my lord, the affair was lost on 14/7/21.
Yes.
And alleged incident of burn injury sustained by the deceased occurred on 12/7/21.
Yes.
And what happened thereafter, your Lordship may turn to page 22. That comments dates at 14/8/21.
Yes.
State government transferred the investigation of the case to the crime branch and the said case was registered as CID PS case number so and so. I am taking a pause here. What happened? What happened? The deceased was then serving as a high-ranking officer in under the government. So it is a sensational issue. For fair investigation, the government so moto, without anybody's approach, transferred the case from the general police to the CID CB. Thereafter, what happened according to them? The statement of the complainant was recorded. Your Lordship, get it? Crime branch recorded the statement of the petitioner and the family members.
1921.
My lord. Thereafter, scientific test was conducted. Your Lordship will get it. Polygraph test was conducted.
99.
My lord. In between, what happened? Before lodging of the affair, I will clarify it, that the statement of the injured who is now deceased was recorded by executive magistrate. That was also relied upon and pleaded in the complaint petition itself. I will refer that later on. Dying declaration. And that is a piece of material which indicate that a executive magistrate in presence of the doctor recorded the statement, and there the deceased has not suspected any foul play. That is the material on record.
That is under 32.
Exact 32(1).
Here.
So these are the materials which has collected during course of investigation. Let us say that all the things were manipulated. Let us check for the sake of argument. Then what are the material placed by the complainant before the court, prompting him to take cognizance under section 302 and also issuing process? That is another question which your lordship has rightly pointed out. What are the materials? If you want to say that there is no case at all, the entire process adopted by the court below by issuing process is illegal. Now, your lordship have a glance to the initial statement. First of all, I will bring my lord's kind attention. Initial statement of the complainant on the reverse page. In the pen, it was written. Complaint petition. So exhibit annex 3 the
Next 3.
3 the
Yes, 4. Yes. Yes, I got it. 34. Page 34.
Page 34. Annex 4.
There is a function in the bar.
Yes, I am aware about the fact. I am suggesting one thing. Instead of thoroughly hearing this matter, but because it involves
It needs
very
hearing.
important question of law.
He has raised in some question. Prima facie, I have to see the judgments if you have. And what you are trying to converse is if the initial evidence on the basis of initial evidence and the scientific evidence, everything in the final report is submitted. No other materials are there. On the oral testimony, subsequent oral testimony, if at all, and 202, whether cognizance could be taken or not.
Yes, yes.
That
That is my solution. And even if that material which has been produced by the complainant during course of 202 inquiry.
What about the dying declaration? What does he?
Dying declaration
Let us see the dying declaration.
Just
with me, my lord.
Annex with
me, my lord. 51. I read out. Read out. Dying declaration. ମୁଁ ସୌମ୍ୟରଞ୍ଜନ ମହାପାତ୍ର କହିବାର ଏହିକି ଯେ ମୁଁ ପୁରୁଣା ଜିନିଷ ଏବଂ ବହିଟିଏ ପୋଡ଼ିବା ପାଇଁ ବ୍ୟବସ୍ଥା କରୁଥିଲି। ଗୋଟିଏ ରୁମରେ ଏକା ଥାଇ ରାତି ପ୍ରାୟ 8ଟା ଅଧେ ସମୟରେ କିରୋସିନରେ ବହିଟିକୁ ପୋଡୁଥିଲି। ଏହି ସମୟରେ ଗୋଡ଼ ଖସି ମୁଁ ପଡ଼ିଗଲି ଏବଂ ମୋ ଉପରେ କିରୋସିନ ପଡ଼ି ନିଆଁ ଲାଗିଗଲା। ମୋର ସ୍ତ୍ରୀ ସେହି ସମୟରେ ଅନ୍ୟ ରୁମରେ ଥିଲେ। ଆମର କିଛି ପାରିବାରିକ ସମସ୍ୟା ନଥିଲା। ମୁଁ ଏହା ସଚେତ ଓ ସଂଜ୍ଞାନ ଅବସ୍ଥାରେ ବୟାନ କରୁଛି। Recorded in presence of
dying declaration and burning injury is 95%.
95% burning injury, my lord.
Maybe, but dying declaration is this. What to do?
Yes, dying declaration is there.
Based on that, charge sheet submitted, my lord.
No implication in dying declaration.
No. But in spite that, charge sheet, my lord.
Even though foul play was alleged.
But the father and mother, my lord, they are 1:1 difference, my lord.
It is a final report for all the expert persons?
No, my lord. So, submitted 304A.
304.
A, my lord.
Only 302 is converted.
Yes. Against the wife of the deceased.
That was against the wife of the deceased.
Charge sheet only submitted.
Against
cognizance is taken in complaint case, my lord.
If the dying declaration is to believe, the wife is also gone out.
Other, my lord. She can raise that point at the stage, my lord. But the wife filed 2 cases, my lord.
Who is the complainant? Is the brother of the
father, my lord.
Father. Who was not in the spot. He was
not in the spot, my lord.
None of the witnesses examined under section 202. They are witness to the how the incident took place. Only they suspected.
Suspect or hearsay kind of.
Not only suspect. Before the incident,
Father was not in the.
No, father was not.
Somewhere else.
Before the incident, the deceased complained before his mother that the BFO, one of the accused, and his wife had illicit relations, and he wanted to transfer from that Parla community to some other place. He complained, and that is also alleged in the complaint case.
202 statement.
My lord.
Absolutely. With due respect to my friend, I said that this statement is not stated by any of the witnesses examined on section 202. Where from his
If these materials are there, then we can think
Clearly mentioned in the complaint
petition. Complaint petition, 202 inquiry purpose. to bring the materials.
202 materials on record.
Where is that material which you submitted before the honorable court?
I am pressing.
It's like, I'll tell you. It's like you collect all the evidences. Police does is, he collect all the evidence, placed it on the charge sheet. By taking money from the accused, say that we will exonerate it. In the narration, they said no cases, madam. But he files all documents, for example. And final report is filed, despite the fact that all relevant materials are there.
Yes.
Final report is filed for consideration. Then the cognizance court has to see the narration made by the police, or cognizance court has to see the material placed on record. He has to see the material placed on record. Exactly similar situation in the protest petition. In the petition, you might have said so many things, but you have to substantiate it by bringing evidence.
Yes.
Those evidence will be considered for the purpose of
I-
not that whatever you said in the
One
protest
second.
petition. Protest petition, you might have said so many things. But you have to substantiate that because the trial has to proceed on the basis of the evidence.
Yes, ma'am.
That evidence, what evidence? The evidence is 202 evidence. Then that will be tested in the trial. So in the 202 evidence, what material you have brought in,
I am pressing.
which has caused the court to take cognizance under 202 has to be looked in. Let us see that 202 evidence, whatever evidence you have brought. Whether is that sufficient in the face of the evidence already collected by the police and placed on record. Whether those evidences are contrary to the evidence already placed on
The
record.
police admitted in the charge sheet that there is no mark of violence inside the spot house. Admitted in the charge sheet, clearly mentioned. I am putting a question to myself. If the dying declaration is that while the deceased was burning a book, he sustained burning.
Whether he has struggled or not, that's what you want. If he has struggled, there must be some kind of indication. that he struggled.
Indication and mark of poda chinha bhi madhya kichi rahiba katha. Clearly it is mentioned that there is no mark of violence inside the spot house. If the witness may lie, but the circumstance may not. Under which circumstance the husband may stated so dying declaration to record when the mu banchi jibi what a stigma.
The presumption is a person who is going to die will tell all the right thing.
Under which circumstance, if at all this dying declaration is recorded, it is admitted that the deceased sustained 95% burn injury. At 95% burn injury, whether the deceased can give a statement, number one question. I am putting question to myself that if 95% burn injury can be only possible if it is a case of suicide or it is a case of homicide. It can be, but not in case of accident. My first submission, my lord.
So
Because if somebody will sustain any
be
injury-
ready. We will put it in a day where I can hear. It will take at least half an hour, 45 minutes, nothing less than.
But first hour rahigale, but time fix ହେଇଗଲେ it will be
I am
better.
suggesting one thing. Your lordship assume specific mentioning 2 PM it will be taken up.
Yes.
So it will be better. First half others will come why they will head up.
Right. No, let us make it 3 o'clock sometime.
Right.
Okay.
I'll finish it up for Passover and then 27 at 3 o'clock. 27 at 3 o'clock. And I would only request that whatever judgments and all this.
Yes.
Prepare a compilation and give so that.
I have filed my judgment, but I am trying to rely, but I will rely already filed.
Interim order to be continued.
Interim order to continue. How many minutes?
Item 59, I plan to accommodate me till next 22nd or
Urgent.
interim order.
Interim order.
Well, several time has taken my lord.
Sorry?
No. I am referring to OPT by not two.
In 59.
My lord.
Okay.
There several time has taken my lord. Fix the date next week, any date, my lord.
But
I'm assuring that I will not take adjournment because of my personal difficulty for to argue to today.
how many time you have taken time? 6:12 you have taken.
twice, I think.
On request of council petitioner. 20th 12 you have taken.
Twice ମୁଁ ଯାହା ଦିଥର ନେଇଛି ବୋଧେ।
3 times you have taken only.
I'm not saying only. My learned friend will be ଆମର ସେ cultural program ପାଇଁ
ଡ୍ରାମା ପାଇଁ ସେ ହିରୋ ରୋଲ କରିଛନ୍ତି ତ
ହିରୋ କୁ ରଖିଲେ last opportunity by way of last opportunity they will short date would be first week time ହବନି କି first or second fourth March no further adjournment will be
yes I assure that I will not prefer adjournment.
No, that has to reflect in the order, no? You are assured.
Item 64, I am for the, but I am not informed.
diabetic patient ପାସ ଓଭର ତାପରେ ଆର୍ଜନ ହେଲା ପାସ ଓଭର ହେଇଛି ପୁଣି ଆଉଥରେ 500 ଟଙ୍କା ଆର୍ଜନ
stay ଅଛି
stay ନାହିଁ ଯେ ମତେ କହିଥିଲେ ମୁଁ ପଳେଇ ଯାଇଥାନ୍ତି ମୁଁ 2ଟା ବେଳେ ବସିଛି ଭୋକରେ
That's the whole difficulty. I'll tell you. Either you have to believe the lawyer who is mentioning.
ନା ଭାଇ କହିଲେ 500 ଓଭର ହେଇଛି ବୋଲି
ନାଇଁ ନାଇଁ ଆର୍ଜନ ହେଇଥିଲା ଆର୍ଜନ ହେଇଗଲି
penalize him. Why are you penalizing? Penalize him. He has misled you. He has misled you. For that, whatever cost you will impose.